All right, ladies and gentlemen, we're going to get started in about a minute. I know there's still some folks that are signing in, and if you're here and would like to get credit, hopefully you did sign in on the way into the meeting hall, and you'll need to sign out on the way out. So just keep that in mind. All right. Let me remind commissioners that you should maybe speak a little slower than you typically do, just because of the reverberation in this room. At least it appears to me that way. And also to remind you that these speakers will remain on and recording even during breaks. So if you want to talk about somebody, go out in the hallway or somewhere, because otherwise you'll be of record. All right. Caitlin, are you ready? Okay. Well, we're a moment or two from getting started. Let me just take a moment to say a couple of things. On behalf of the Commission and staff, I want to again thank the Memphis Area Association of Realtors for the hospitality they showed us last night. It was exceptional. And I think part of it was because the two commissioners that are here today from Memphis did some arm twisting. I'm not sure if that's true or not. Steve Gwynn from Memphis is at the far end. Let me just go through the commissioners so you know where they're from. DJ Ferris is from Nashville. John is from Lancaster, wherever that is. Marcia's from Franklin, Tennessee. Joan is from Humboldt. She was recently crowned the Strawberry Queen at the, isn't that right? Something like that. Strawberry Festival. Jeff Diaz is from Memphis, one of our hosts here this week. And Joe Begley is from Kingsport. And if you don't think yesterday was a long drive for Joe Begley, you'd be mistaken. Fortunately, he got to ride with me, 350 miles of it or whatever it was. And I'm from Knoxville. So with that said, and as soon as we get the okay from our executive director, Caitlin Maxwell, and you'll hear her speak occasionally today. Next to her is Ross White, who's the education director for the Tennessee Real Estate Commission. And we have two attorneys that will present cases to us and or give us advice on certain issues as we go through the agenda. The floor typically is not open to comments from members of the audience, but during breaks you should feel free to approach any of us and ask us questions or tell us what you think about a certain topic, and we're happy to try to oblige. All right, Ms. Maxwell.
Okay, we're ready.
We're good to go. At this point, we have some technical things that have to happen just to satisfy state law or regulations required by the Department of Commerce and Insurance. The first of which is to read into the record a public disclaimer. And Ms. Maxwell will do that at this point.
Okay. Notice of the May 12th meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since October 19th, 2021. Additionally, this month's agenda has been posted on the website since Friday, May 6, 2022.
That was legalese. Now she will call the roll, so on the record will be recorded as present or absent.
Commissioner Joe Begley.
Here.
Commissioner Jeff Diaz.
Here.
Commissioner DJ Ferris.
Here.
Commissioner Marcia Franks.
Here.
Commissioner Steve Gwynn.
Here.
Commissioner John Moffitt.
Here.
Commissioner Joan Smith.
Here.
Commissioner Stacy Torbett. Chairman John Grease.
Here. In the opinion of the chair and the executive director, we have a quorum, so we can continue on with this meeting. At this point, I would ask Vice Chair Marcia Franks to lead us in the invocation, and following that, if you'll stand, she will lead us in the pledge to the flag. Ms. Franks.
Let's bow our heads, please. Heavenly Father, we thank you for this beautiful day here in Memphis, Tennessee. We thank you, Lord, for affording us the opportunity to be here in this wonderful facility. We thank you, Lord, for all those who've made this day possible. We pray, Lord, that you give us discernment and mercy today as we make decisions that affect people's lives and their livelihoods. We appreciate all that you do for us and all the blessings you give us. In Jesus' name, amen.
Amen.
Will you stand, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Marcia. Next up is to approve today's agenda, which has been sent to each commissioner. Any additions, corrections, or deletions, Ms. Franks?
I serve on the Professional Standards Committee at NAR with Greg Glosson, and he has asked if he could say something about instructors when we get to the education report under the instructors. Ross, if that would be okay?
Yes.
Okay.
So you did advise him of the chair's impatience with long-winded comments.
Where'd he go? Oh, there he is. Make it short and sweet, Greg.
Let's get to the point, okay, Greg? Thanks, man. Appreciate it. All right, any other additions?
Motion to approve is amended.
Okay. I have a motion by Mr. Diaz, seconded by Ms. Smith, that the agenda as amended be adopted. Any further discussion? I hear none. Let's vote. If you're in favor of that motion, vote aye.
Aye.
Opposed, vote no, and that motion passes unanimously. All right, next up is to approve last month's minutes. You also received those. Mr. Bagley reviewed them in detail and makes a motion to approve those minutes.
I do.
Second.
Okay, and seconded by Ms. Franks. Discussion? Let's vote. Those in favor of that motion, vote aye.
Aye.
Opposed, no. And the minutes are approved unanimously. All right, next up is an informal appearance. For the audience's sake, we have an informal appearance that's going to be done remotely. Is that correct?
That's correct.
Okay, and I know we have very little information at the moment about that applicant,
Yes.
but I can find it on my iPad.
You can find information on your iPad, yes. And we.
If a person is capable of using an iPad, he
That's
should
correct.
be able to
Yes.
find it. Is that what you said?
Yes.
Okay. Thank you, Ms. Smith, for your help. All right, Caitlin, give us a little background, and then we'll proceed.
Let's make sure. We're looking for Kimberly and Susan to be present on the Teams meeting.
So the applicant is Kimberly,
The applicant is Kimberly.
and her broker
Is Susan.
Susan. Kimberly, can you hear us? Susan, can you hear us? All right, if everyone will stand by for a minute.
We can move on to the.
Okay, we got it. So let me just do a quick check here. Miss Kimberly, can you hear us?
I can hear you. I don't think Kimberly can.
Okay, so you're the broker, right, Susan?
Together.
Kimberly?
Am I any relation to her?
No, you may be. That wasn't the question. I'm trying to see if Kimberly can hear us. So, Susan, since we can't hook up with Kimberly at the moment, we're going to move to another item on the agenda and then come back and see if we have you both at that point. Understood?
The communication, it's real scratchy from y'all's end. I think she's hearing about what I'm hearing a little bit at a time.
So assuming you both can hear me at this moment, we're going to work on that and move to another agenda item in the meantime. So stand by and we'll try to improve the communications. All right, Caitlin, let's go to waiver request of Michelle Graham.
Okay. We have an E&O waiver request for Michelle Graham. She was revoked due to a lapse in E&O insurance for her license being suspended for a year. On your iPad, you'll see a summary of the request. She has paid the penalty, but she is requesting waiver of the exam. You can find the information in a letter on your iPad.
All right, so to the members of the audience, we have a licensee whose license has expired because she did not pay her errors and omissions insurance in a timely fashion, which means up to a year after it was due, she still could have paid it and kept her license. At this point, she has paid the $1,100 civil penalty because her license went so long without errors and omissions insurance. But in the meantime, because it took more than a year for her to do that, her license was revoked. And today's request is for this commission to not make her take the test again. And so let me start with this question. Do we have the authority or anything in the statute or our rules or regulations that give us the right to waive that test?
I'm going to consult with the attorney, but there is a part of the statute.
Hello.
Good morning, Anna.
Good morning.
I'll just come up there. So, the statute that we're looking at for E&O is going to be 6213-112. So if you guys have your green books, red or blue books, that should be around page 18 to page 20. We're looking specifically at Section L. So, Section L talks about a license that's suspended for more than 1 year and how it is automatically revoked. So, it talks about the different types of notice that's to be provided to the licensee, but at the bottom, if you look at L4, it states, upon revocation of a license, any individual seeking reissuance of a license shall reapply for licensure and pay the penalty fees in subsection K, provided, however, that the Commission may, in its discretion, A states, waive reexamination or additional education requirements for such an applicant, or B, reinstate a license subject to the applicant's compliance with such reasonable conditions as the Commission may prescribe, including but not limited to payment of a penalty fee in addition to the penalty fee that's provided above of not more than $100 per month or any portion thereof from the time of revocation.
So the answer is yes, we can.
Yes, so you have discretion to do that.
Okay, so commissioners, at this point we can have a discussion about the request, and if at the end of that discussion someone wants to make a motion to waive the retesting, it's in line, in order, and we can vote on that. Or if somebody wants to make a motion to not waive it and require this applicant to go, this licensee to go back and take the test again, that's also in order. So we have options at this point. Who would
Mr.
like
Chairman.
to start the
Question.
discussion? Steve Gwynn.
I'm a little confused on what she was talking about in her email about a referral program. Do you think that she was thinking, because she was on the referral program, whatever that may be, that it may have eliminated, or what's going on there? Does anybody know?
I feel like the biggest problem is with their principal broker.
Right.
As a principal broker, I know when people's licenses are expiring. I have their licenses. Actually, I had one of my agents got a blue card just yesterday saying his license would be, he needed to renew. And so I know you're giving warning about it, or not really warning, but you're given the opportunity in advance that Trek is doing that. And I know some years ago you were on your own and you just had to know when your date was. But today they're giving a lot of notice about it. And as a principal broker, I would be saying, you've got to pay this or I'm going to release you. And obviously that didn't happen for this person as far as we know. I don't know if that's a defense or not either, though, because they should have learned that they had to have E&O insurance when they took the licensing course.
Jones or Jeff?
Well, that was going to be my question to staff. These warnings about not being on E&O and her license expired. Those were sent out to her addresses that you have on file.
Right. So, for example, if you're on the state's, policy, they start sending a reminder email in October. And then the policies usually end 12/31 for this particular cycle, end at 12/31/2020. So a new policy would have started 1/1/2021.
Right.
And you're still getting reminders. And at that point, from 1/1/2021, you have until, in this particular cycle, up until 1/29/2021 to renew your policy without any action being taken. 1/29 is when we started suspending licenses. But then even at that point, 1/29 up until I think it was March, 30 days, it was like March 3rd or 4th, you could still reinstate your license at that point with no penalty.
Staff is communicating with her and her broker.
All the information is
both times.
communicated via letter. So a letter is sent to the affiliate's license, their home address. It's sent to their brokers, their firm address. It's also sent to the principal broker's firm address as well.
Chairman, not to end discussion, but I'll go ahead and move that we deny this request.
Second.
Motion by Mr. Diaz and second by Ms. Franks that this request be denied. Further discussion?
I do have one question. So she just sent in the check of $1,100. And so did we deposit that check? Are we holding that check? Or how does that work? I mean, because if she was revoked, she really shouldn't have even sent a check in.
Correct.
So do we give her that money back or what's happening?
So the check is part of the requirement to become active. So that money is held on her licensing account. Her license is still revoked until she meets all the requirements to be reinstated, which once you've gone into revocation, you also need to retake the exam.
All right, other discussion. The motion is to deny the request. Let's vote. Those in favor of that motion vote aye.
Aye.
Opposed, no.
No.
And that motion passes on a 7-aye, 1-no vote. Mr. Ferris votes no. Now, Steve, I'm going to, just for a moment, on that question about a referral company, in my marketplace, and it may be different anywhere, by state law, a broker can broker two different offices, two different companies, as long as they're both in the same location. So there are brokers in my marketplace that are tired of trying to be in the real estate business, but they don't want to give their license up. And they don't want to pay the realtor dues or MLS fees, but they want to keep their license. So in my marketplace, there are companies that have these referral programs where you can move your license out of the realtor organization business into a non-realtor organization real estate company and park your license there for the sole purpose of referring business to other professionals so that you can collect a referral fee. So it's hard for a lot of agents to totally give up their business. But they don't want to be doing it, but they don't want to give up their license. So they can move it over into a referral fee and all of a sudden not have to pay realtor dues and MLS fees. And so I suspect she thought maybe if I got over here in the referral company, state law won't apply when it comes to E&O insurance, which is a bad thought to have. Because the license is still active as far as the real estate commission is concerned. So that's what I think she was saying. But I think the commission has made their decision and it's time to move on. Is Aaron working on this?
Yes, I
We'll come
would
back
say
to-
we'll continue. We'll come back.
Okay. Let's move on to the education director's report. Mr. White is the gentleman who reviews all courses and then will make a recommendation to us about courses and instructors. And apparently you were pretty busy this month.
Had a busy month, Mr. Chairman. Good morning, members of the commission, and to our audience. I can defer to Mr. Clausen if we want to take him first, or I could go on into the report.
I'm trying to decide who will talk last, and I'm sticking with you so far.
Well, all right. Moving right along then. In front of you today on your iPads is the education agenda for May 12th, 2022. I have reviewed all the providers, their courses, and the instructors for today's agenda. M1 through M75. So I present those to you, Mr. Chairman, members of the commission, this morning for your review and approval.
All right, so the education director is recommending approval for courses M1 through M75. Before we take that topic up, does any commissioner wish to pull a particular course out to discuss? All right, that's good news. Sensing that, is there a motion to accept the education director's recommendation and approve courses M1 through M75? Mr. Diaz makes the motion. Ms. Smith seconds the motion. Now discussion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those
Aye.
opposed, no. And those courses are approved. Thank you, Mr. White.
May I ask a question?
Sure. Pull that right down.
I'm noticing that some, and I may have jumped to something else, but on your on the real estate school summary,
Yes, ma'am.
there seems to be some of these schools that has a high rate of failed. Is that normal? Could you? I guess I'm saying, are the same instructors at those schools? Are we seeing anything like that, or is that anything we need to be concerned about?
Well, Commissioner, I think it's something to be concerned about. But as you take it across the board, there's a sort of a lacking diminution, if you will, of the pass-fail of failure rate.
Right.
And if the commission wishes to take that up, then that is something to think about. I don't know if you want to do that today or another time, but I believe that is the case for across the board. And then there are certain ones that you could take out of that mix and look at, to analyze.
Right.
So at the moment, we've published those just for information purposes. So
That's correct, Mr. Chairman.
if somebody wanted to go take a course, they could look at the providers that we've approved and see the success ratio of each of those schools as far as pass-fail goes.
And where are those published?
Well, we, of course, I include those in my education report to the executive director each month, and then we I think we compound those and put those on the website in a yearly. That's the general thing from PSI.
And I can tell you that this is a nationwide problem, and what people are failing is the national part. It's usually not the state part that they're failing. But it is, it is pretty bad when some of the schools are 75% of the people that have taken their classes are failing. We don't regulate the schools as such, Joan.
Right.
So it's only, it really comes down more to the instructors. It is a problem. I just don't know what exactly we can do other than just try and keep our standards high.
Mm-hmm.
So, Jeff,
Well, I wonder, instructors come up for renewal, just like licensees do. They have to get reapproved by this body, correct?
Yep, that's correct. Every 2 years, the instructors and the courses in our educational cycle, and this is the year for renewal at the end of the year.
So I wonder if you might include their annualized pass-fail rates that you compiled already into their application to reapply for us so that we can see it and maybe render judgment, have that to add to our judgment?
Just to be clear, you could see the pass-fail rates for the providers, but there are no analyses for the instructors. And the instructors are separate as far as their license is not, they're autonomous from the providers. They can work for several providers. They can have a contract to work for one. But as long as they're licensed in Tennessee, they can go from Mountain City to Memphis to put on courses for approved providers. But we don't really analyze those in that way simply because the courses belong to the providers.
So if we wanted to gain access to that information, we'd have to get it from the providers on an instructor-by-instructor basis?
I think that would, yes, I think that would probably be it. And then you'd have to correlate that with the pass-fail rate.
Right. I mean, I'm not.
And maybe
It's painful.
Maybe
I know
I
it's
just
not
opened
simple.
up another discussion, but it does concern me when I see the fail rates in some of the schools being higher than others.
It's why we need to really, really look at the credentials of people, and he gives that to us when we approve instructors. And I think during the pandemic time that there were a lot of people that, because they weren't doing a lot of business, started teaching, hoping to have some income from teaching. And the only thing that we can really do about it at this point is, I wish we could publish it where, I'm a commissioner and I've been here 9 years and I didn't know where to look for those other than I have my monthly report. For the general public that we're supposed to be protecting, I think it might behoove us to put these scores out a little more widely in our newsletter or something. But, and we know we have pages and pages and pages of these classes and instructors, so it's not a small thing to even put it in a newsletter. And then we've got to be careful about, because we're not regulating the schools, we can only do it for those. It's telling this number by the schools, not by the person who's given the class, right?
Yes,
not the instructor.
it's really not saying it by the instructor. Mm-hmm. It gives the pass-fail rate by the provider.
Mm-hmm. And, credentials, they give you some certainty, some degree of comfort, but they're not a silver bullet either.
I know.
You can have credentials, but they be a terrible instructor. And on the federal side, it's particularly important because you have a Fair Housing Act, you have all the RESPA, all these important laws that agents are expected to obey as everybody else is. And if they're failing that section, just because it might be a nationwide problem, we can do what we can to try to fix it here. So I don't know what the logistics are involved in trying to match instructor and pass-fail rate after their class, because the exams typically are given at the conclusion of class, correct?
If there's so many hours, then
so it's 8 hours that they get an exam?
That's correct. It goes along with that course.
I think it would be useful.
Yeah, and
personally.
especially for principal brokers, when I have someone new come to me and say, where do I go to school? What class do I take? I have this information because I'm a commissioner that not everybody else has. And I know the ones that are failing, and I would never send my people there. So, I don't know what we do, but I think it's something that we need to put some focus on. And, everybody think about this, and maybe next month we discuss it again. I'm not sure, and I think from our legal team that maybe they can give us some advice about that too, because there may not be anything we can do. I'm not sure.
Steve, go ahead.
Question. Ross, do we have people that don't take a course that pass the exam? I would think so. Or there's no mandate that you have to take a course.
Yeah, there is.
You can't just take the test.
Well, you got your pre-licensing
Your
hours that you have to
pre-licensing.
get.
That are required by the state
There are two kinds of courses, the pre-license and the
and
electives.
the broker management.
And if it's an elective, if it's so many hours, then there's an exam they have to pass. If it's over 8 hours, they have to pass an exam. But I just want to be clear, that's not the same thing as the pass-fail rate that we publish from PSI, because that's talking about the real estate exam, not the course exam.
Okay, we are
I was
going
just
to
going
hear
to say,
from
we
Caitlin
can,
Maxwell next. Go ahead, Caitlin.
we can make it a standing item in the newsletter. We've included it once before, but we can just make it an item that's included in every newsletter so that it gets highlighted there.
That would be great.
Thank you.
Okay, Commissioners, Mr. White's about to make a recommendation on instructors for this month. Mr. White.
Thank you, Mr. Chairman, members of the commission. Yes, before you today there on your iPads, I believe we have Form 1 and 2 of the instructors' backgrounds, and I present them for your approval this morning.
So that's 5 instructors, is that right?
I believe there are 4.
There's 2 pages.
2 pages.
Yeah.
It only holds 4 a page, so that's
They're the same.
You agree it's 4, not 5?
I don't see the 5th one.
In any case, it'll all go into the record as a recommendation of the education director. Is there a motion to accept
see it.
the director's recommendation?
So moved.
Mr.
Second.
Mr. Ferris makes a motion. Mr. What's his name? Joe Bagley makes a second. Discussion. Let's vote. Those of you in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right.
Mr. Clausen.
We were going to get, I think, I'd hate to keep people tied up on this phone call if we can talk to them. If not, we're going to keep moving until we get that straightened out. Ross?
I did have one more piece of good news before we move along. On our website, I meant to mention it last month, but we now have an instructor's listing, such as for courtesy, that we now have that in addition to our course listings, provider listings. So we have an instructor listing.
All right. I'm going to wait for Aaron to get back. Do you think, Caitlin?
From what I can gather, the group can hear, but I'm not sure. Kimberly, if you've made it onto the Teams and can hear, let us know.
Okay. All right, we'll come back. Mr. Clausen, we'll get to you. I mean, Ms. Franks put you on there. We're going to hear from you. All right. So we're about to have an informal appearance virtually. And on the line with us is a licensee or a potential licensee and his or her potential broker. And somewhere in the past, this applicant had something in her history that's caused her to have to come before this commission to get approval to continue on to get her license. Or the commission may say, no, we don't think we will. So we're going to hear from Kimberly, whose name I still don't have the last name of. Do I need it? I don't need it. You tell me that.
I don't have it as well, so
How do we know we're talking to the right Kimberly?
well, we specifically gave her the link to the
Okay,
meeting.
I
so
got you. So, Kimberly, can you hear me okay? Okay, I'm going to talk slowly for a second. Here's how this procedure will work. In a moment, we're going to give you the floor, and you can tell us about the event in as much detail about the event as you would like that caused you to have to be here in front of us. You can tell us what you've been doing since that event. You can tell us anything you want to, as long as it doesn't take most of the day, to tell us why you would be a good prospect to have a real estate license in Tennessee. When you are finished, the commissioners present can ask you questions, and following that, we're going to turn to Susan Green, who's your potential broker, and ask Ms. Green why she'd be interested in having you affiliated with her company. And following her remarks, commissioners once again have the right to ask Ms. Green any questions or go back to you based on what Ms. Green said to see if they have other questions for you. And eventually, and if we're efficient, it won't take too long, we're going to make a decision whether to let you go forward to get your license or suggest you might need to wait a while. So do you understand the format, Kimberly? Yes. All right, I'm going to turn the microphone, your microphone, over to you. You have the floor. Tell us what you want us to know. No, that's fine. Thank you for that. Just for the record, the reason that Kimberly has to be here today is because, if I'm wrong, Anna, tell me, but I think she was sanctioned by another state agency. Is that what caused her to get here?
That's correct.
Okay. All right, Commissioners, you would like to ask questions of Ms. Kimberly, Ms. Franks, and then Mr. Ferris.
Good morning. Good morning, Kimberly. I wanted to ask you, so you signed a consent order when you were sanctioned under the nursing board, and one of the lines that I had a question about was, it says, respondent also stated a family member of respondent removed the medication from her purse, and she was no longer in possession of the medication. But what you just told us is that you put it in your vehicle, and your vehicle was broken into and stolen. So what exactly happened?
Yes, it was. It turns out that it was actually my brother, who I had not had much contact with, but he did. He went through my husband's stuff and our house, essentially. He's now in prison, but it was a bad situation. There's a lot of minor changes in methamphetamine, which he's no longer in our life, but yes, it was. And that's what I called out and happened, at home here. And I wasn't sure what to do, I guess, in that situation. But yes, it was my brother's mom.
And did they make a police report? Did you make a police report?
I did. I spoke with an officer, and he told me that he had applied to Illinois. He also said here, I've never been pursued. It was not going to be a problem, is what I was told. And I relate that to both my management and the police department, and they told me that Illinois would have to be open, and they did, essentially, even for the next.
Okay, that's all the questions I have.
Mr. Ferris.
Thank you, Chairman. What's your name again?
Kimberly.
Kimberly. I wanted to say Caitlin. Kimberly, thank you for joining us today and sharing that story. Was there a family connection with this patient at the time? Was there any, or was it a patient you were not connected to?
There was family dynamics in this patient's home as well. There was suspicion of abuse, and they had a paid caregiver who had been filling the medication box, which was not appropriate, and had been discussed with the family. So there was talk at the time of possibly revoking the patient, and there was a lot of back and forth about what we could do to control the symptoms and also manage the family, the environment. But I was not directly.
Okay. No further questions. Thank you again.
Other commissioners?
So the question is, are we going to allow her to take the exam? Has she already had the exam?
She has not.
So let's go to her proposed or anticipated broker, Ms. Green, and let Ms. Green, I think it's Green, correct?
Susan Green.
Susan
yes.
Green. Tell us why you're interested in having Kimberly affiliated with your firm.
I had the pleasure of meeting Kimberly last March. She was a hospice nurse for my brother back in April the 24th of last year. And I've been in real estate, being in Nashville for 57 years. I'm pretty good at reading, and I just
right, thank you, Ms. Green. Questions for the broker, proposed broker? Other questions? All right. If there are no questions, then
Motion to approve this applicant.
Chair was happy to entertain a motion from
Second.
Mr. Diaz to approve Kimberly to move forward to get her license. Ms. Frank seconded that motion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. And that motion passes unanimously. So, Kimberly, you had me at hospice nurse, okay? And so I've got a feeling you'll have more emotion when you get in the real estate business, you can imagine at some point. But we wish you the best. We expect the best for you. And you've got a broker who cares, obviously, and you make that broker proud, and the broker will do all she can to help you as well. So good luck. Thanks for coming on today. Take care. Okay. Let's go back. Let me check the time here. Yeah. Let's go back to Marcia's request to ask Mr. Greg Clausen to come up and say a few words about instructors. That's the topic I have at this point. Please come up.
And Greg, will you tell us a little bit about yourself and what you have to do with education?
Sure.
Thank you for letting me speak to you, Commissioner. And Mr. Chairman, I did notice Mr. White spoke for about 18 minutes.
He was interrupted several times.
I just wanted to make sure I would have the same 18 minutes.
On the payroll, and you're not, okay?
Yes, sir. Thank you very much. I appreciate that.
I'd like to note that he stood for 18 minutes. He didn't talk for 18 minutes.
I stand corrected, Commissioner. Thank you.
You've got the floor.
Thank you. My name is Greg Glosson. I'm from here in Memphis, and I also own a real estate school and am an instructor as well. And I noticed last month when you all had your meeting, you were discussing the governor's signature on legislation that changed the terms with Orello, and that there was no longer Orello approval needed on distance courses. When I was in Washington and spoke with Vice Chair Franks, we talked a little bit, and I did ask if it was appropriate for me to have the conversation before I did.
You did.
But we did speak for just a minute about the Certified Distance Education Instructor certification. This would not have any impact on the live courses that we do throughout the state right now. The instructors would still be approved as they currently are, and the courses would be approved as they currently are. The point that we were trying to make is with the distance courses, whether they be a hybrid type of course or strictly distance. And the commission could, based on my understanding of the last meeting, the commission could put into place a policy that said that the instructors who were doing those type of courses would need that certified distance education credential as well. And I was just going to offer that as a suggestion to the commission because again, through the video that I saw of your last meeting, I think there was some concern about how there would be, I don't want to say follow-up isn't the right word, but accountability for some of the courses. And Commissioner Diaz, you said on another subject a few minutes ago, it wasn't the silver bullet, nor is this. It's not a silver bullet, but it is a starting point for the commission to consider.
Thank you. I think my recollection of that meeting was that there was generally a request and that some guidelines be established. And it had more to do with the course and the instructors at the time, but your focus today is on the instructors aspect of it.
The instructor aspect of it, yes, because if we're going to continue to allow, which the legislature has done, if we're going to continue to allow distance courses, and clearly we all know that that was a success, if we're going to allow distance courses, we need to have some sort of way to differentiate those instructors who are doing the distance education, and this certification certainly could do that.
And that certification would be through Orello or through?
It is a Orello affiliate company. Is that correct?
It's an Orello certification.
Yes, it is.
So you're speaking in favor of distance instructors being certified by Orello?
Absolutely.
And do you know what that would cost, or how often it would have to happen?
It renews, to the best of my knowledge, it renews every 3 years, if I'm not mistaken, and the cost is
$450.
$450. Yeah. And again, it gives the commission some
3 years
knowledge or understanding that at least this instructor has completed that as well.
It doesn't mean they're going to be a great instructor.
Does not mean anything like that. No, sir.
Okay.
No, sir.
All right. Can I ask Mr. White, do you have any comments on that at this point?
Yes.
Please come to the microphone.
And Mr. White is actually on the committee at Arello for both education certification and education in general.
Mr.
I
White.
am. Thank you, Commissioner.
The instructor.
Yeah, we're
aspect.
on the instructor issue. So right now, the law requires that Arello certification be part of their resume, part of their requirements to become licensed as a instructor for TREC. That is for asynchronous courses, all internet courses that can be taken at any time of day or night. We still require that they have to have their certification from Arello. That's for the asynchronous. Now, for the synchronous that began last month in that discussion, it sort of begs the question now, as before, when the law took effect, actually before the law took effect, then we were looking at if the instructor had synchronous, if we knew it was going to be a synchronous course, then they would have to have certification under Arello for synchronous courses. So there's two different kinds.
So just let me interrupt for a second. A synchronous course is one that's taught live, but you can participate online at the same time?
That's correct. That's a distance course as well. It's real time.
Okay.
Hey, Ross,
Yes.
thanks for sharing some more of this. If I am an instructor and I have obtained the Arello certification to do an asynchronous course,
Correct.
what further certification through Arello will say, Mr. Ferris is good to do asynchronous, but he's not certified to do synchronous? Like, what am I paying? As an instructor, would I pay one fee for each, or I'm trying to educate myself more on.
That's a great question, Commissioner. I think that once they have their asynchronous certification, then that's going to, it's up to the Commission to make that decision whether or not you want to additionally require the synchronous certification, and that's what Mr. Clausen just spoke on. If you want to make that additionally, now with the new law, there's no requirements for courses to be synchronously presented, but it really doesn't touch on our instructors. And heretofore, that's been a policy of the Commission that at least for distance courses, asynchronous, that they have the certification. And then once it was made last year, it became a law that the synchronous, we adopted that as far as the Arello requirement for synchronous. We were looking for instructors to have that synchronous certification as well.
Okay. Thank you for that. Enlighten me a little bit more, because as I'm understanding it now, and there's people in the room who are far more versed in this topic than I. If I have got the credentials and I have been certified for asynchronous courses, I've got the stamp of approval, I am conducting my courses in a stellar manner. In my mind, in this moment, the difference between a synchronous, the only thing different is what type of technology is watching me give it, what type of proctors are helping me make sure the classroom is attending, and
DJ, more than anything, this certification, it's called the Certified Distance Education Instructor Program. And what it does is it gives instructors a credential showing that they've had training in teaching adults, number one, because that's a little bit different than teaching children, and then also principles of good practice for teaching online. So it's just like I have a CRB. As a broker, I've gotten that. I have that on next to my name. It gives me some more, shows my qualifications. This is an indicator of the qualifications of the instructor if they have this. And this is not required in the state of Tennessee right now, is it, Ross? It's
That's correct.
It's not required. So it's just an additional, if you wanted a GRI by your name, it shows your...
Okay.
So that's a credential, and that's, I think, what Mr. Glosson was trying to say is if we suggest that this might be a good way for people to go as far as getting certified to teach in
Ross.
that way.
Yeah, I think if instructors and certainly licensees, certainly members of the public, if they can self-govern and make that decision on their own, then that's fine, and I would be more supportive of that.
Mr. Bagley.
I mean, there's nothing that's saying that someone can't get certified. I mean, they can get certified and use like your GRE. It's just saying that we're not mandatory at this time, right?
For synchronous, that is correct, Commissioner. For asynchronous, it is mandatory, at least if you look at it, for the courses. For the providers, for the instructors, that's been a policy. It's not included in the law nor the rules, but it has been the commission policy.
So as you're approving, or as you present those instructors to us for approval, that you've taken that in consideration as to your checklist of things that are required for that person to teach those courses?
Absolutely, Commissioner.
All right. Anybody else? We're gonna take a break. We may come back and talk about education a little bit more. We may not, but don't go anywhere, all right?
Okay.
All right, to members of the audience, we're going to take a 10-minute break, which means we'll start back at 1:45. And just for your information, you don't have to sign in or sign out during breaks, but the sign-up sheet will be put back out there maybe a couple minutes before we end the session. So don't be like I used to do and try to sneak out there early and sign so I could get out faster than anybody else, because it won't be there for you to do it. Come back at 1:45 and we'll get started. Thank you. I can hear that, those bells calling.
Everybody turn your mic off.
Thank you.
to share my
They have it.
Oh my gosh. Is that your Oreos? Yes, because you got that strawberry. Where are you going? You're coming up here with us. Yeah. I think you should.
All right, commissioners, let's get back to work. Okay, Ross, we're going to go back to talk about education, but before we do that, I would like to recognize a former chairman of the Tennessee Real Estate Commission. He was a chairman when I first got on the Real Estate Commission many years ago, and I didn't even recognize him because he's got a beard or something. Where are you? There's Isaac Northern. Stand up, Isaac. Now, with that said, back in the day, when Isaac was chairman, we had two-day meetings almost every day, every month. Thank you. Days, months. And we got to socialize a lot more. We'd take a couple-hour break for lunch, and we'd go to Jimmy Kelly's for dinner one night, and I'd go back there the next night. And we got to know each other well. And Isaac was a true professional. We also had auctioneers on there, a guy named Bear Stevenson who wasn't worth shooting. But he was a fun fellow to have around. But anyhow, it's good to see you, Isaac, and I'm glad you're doing well. Bobby Gillis also was a past chairman of the Real Estate Commission. She's not here today, but I always thought well of her, too. She did a great job. All right, with that said, Ross and commissioners, let's forget instructors for a minute and talk about some proposed guidelines to deal with the new piece of legislation that has just been passed. And I think each of you received some documents from Caitlin and or Ross related to some statistics as well as to some guidelines we may want to spend some time talking about. So Ross, I'm going to give you the floor, and we're talking about courses now, not instructors.
All right, Mr. Chairman, thank you, members of the commission and audience, and bear with us. But there were a number of documents that I passed to the commission this month to review in anticipation of talking about the synchronous course issue. I guess to call your attention first, I did a short page-and-a-half report memo that basically outlined what kind of I go through or expect as I see courses come to me now. So that's just a introductory report. And then I included several other documents that I think are useful. One would be jurisdictions that require RELO certified courses for synchronous education, and could call your attention to that. I'm not sure if it's on your iPad, but I assume it is. And so you see those marked, and you see the certain states in yellow that actually require it versus those that either do not require now, as Tennessee goes, and we're talking synchronous, or other states that don't require but recognize, like Kansas. So you have all of them listed there, along with some provinces in Canada and so forth. So then just under that, again, in anticipation of what we probably need to consider, our TREC guidelines. We have guidelines now, and I also included those that are still on the website, but now we're in a new day, and so the TREC guidelines for synchronous courses, we adopted pretty much what we had, but at least some additional things that we thought would be pertinent to what we need to do to protect the public and to ensure that we have the best in real estate education. And that's all that we're trying to do here. And so Caitlin and I and Anna, I think, basically put pen to paper and combine things into what we thought we would present to you today for a potential approval. If approved, we would adopt these as it relates to synchronous courses.
And to be clear, the reason we're even visiting this issue is the state legislature recently said these guys don't have to be approved by a RELO specifically, but have to be approved by a body of some sort.
That is correct, Mr. Chairman, and that we also included in that the PC 93, I think, whatever that actually the law was. So you can see the verbiage in that.
And so the sense is that probably the commission will approve these courses in the future. Is that where we're going, or?
Yes, we're looking for your approval as far as the regulatory administrative chore that I do, and just want to be sure that we're in sync there on that, and the commission approves that.
Okay, so commissioners, I'm going to let Caitlin speak for a moment, and then we'll get your thoughts.
I was just going to say, Anna would like these to be in rule, or at least referenced in rule. So the plan would be for you guys to review them today, make any additions, edits, and then next month Anna would bring a red line to put it in rule. Legal likes rules, not policies or practices. So
Dang attorneys.
That is correct.
All right, commissioners, hopefully you've had a chance to look through them. This will be, when we finally codify whatever it is we come up with, will be benefit to staff as well as instructors, as well as providers, because it'll be a clear path to what has to happen to get a course approved by this commission for synchronous courses.
Mr. Chairman.
Yes.
Ms. Matlock, is it your intention for not only the suggested new guidelines, but the existing guidelines to be codified in the rule? Is it your intention for that?
No.
So the existing guidelines are at the top of page 2,
Right.
with some of the red lettering is clarification to the existing guidelines, and then under that would be the additions to consider. And then on the very last page, you'll see what is currently on the website. Now, what is currently on the website was primarily when the executive order was in place. So we would like to get all of this, all the guidelines that you guys would like included together today, and then Anna will bring back a rule. What we have right now on the website was really primarily more for when the executive order was in place.
Okay, so, but you want what's in place right now, plus these additional guidelines. You want our preferences in terms of what's going to be enshrined in this rule.
Yes. And ideally, I don't want to speak for Anna, we would like for the rule to almost be reflective of kind of how the core courses, where you guys vote every year on additions to the topics within the core course, because as we know, things change with education, and what is required today might be different than what we need tomorrow. So we would like to put it in rule, but allow for additional flexibility to where if something new comes up, we could add additional guidelines to reflect a change in technology or a change in the way that students.
Mr. Chairman, it would be helpful to me if we could have input from various education directors from the associations as to what is practical in the field for them to be able to implement whatever we decide on.
Along those lines, if I could,
Sure.
Commissioner, I also included several. I took a national listserv with Arello and sent out a request for information to come back with, so that the commission could review that. All of it was not, it was so much we couldn't put it all on your iPad, I think. But anyway, several states, just want to point out, that require the synchronous certification, including Texas, Nebraska, South Carolina, New Hampshire, Alabama, Idaho. So at least 6 states, we had 7 at first, but 6 states responded, and one we found out did not require the synchronous. Texas doesn't require it.
So, Ross, what we're looking at is first of all, I'd like to thank the Memphis Association of Realtors, because they really
equipped us when the pandemic came on us, and we were having to figure out, what the rules should be. And we were at a meeting in Memphis, and they brought all this to us, and I appreciate that. What we're talking about, though, is combining it into one document, not having two separate documents.
Right.
And the red letter are the things that you are adding to it. Is that correct?
That's correct.
Now, the one thing that I don't see on here, the most concerning thing to me about synchronous courses is, what if there are 200 people on the synchronous course? Are we going to have any kind of number as to proctors? And at a certain amount of attendees, you've got to have proctors. If you have 200, you might need 2 proctors. Is there been any discussion about that?
It was presented to me by one of the statewide providers that perhaps we could consider 30 people. I don't know if that seems to be a bit much, but they also pointed out to me that, yes, if you have a threshold of 30 people, then you'd also have to have a proctor at that point, so that would be an included item. Well, proctors cost money too, so they just want us to understand that whatever threshold number we come up with, that is an additional cost to them, right, the presenters of the education. However, I believe that our education is the paramount consideration here, and that the people that we're trying to help, of course, are our licensees to get the best education possible. And we're in a new day where synchronous is the new rule. It's going forward. We're not going back. But without some guidance in the commission, we're not going to be able to really signify the things that we need, and we want to promote education and not go back the other way.
Mr. Gwynn.
A couple of questions on the red lettering or the changes. What does reliable internet connection mean? Do we need to specify a speed, or that seems a little bit loose to me?
Yeah, so I was just going to backtrack. The way that we came about these is originally MAR so graciously sent us the original guidelines that they were using, that they had also sent around to other associations to use. So those are the, under the TREC guidelines, those are the originals. The red lettering there is clarifying some of what was on there. And then Ross did reach out to all the other states to ask for if they had guidelines. And so the additions to consider came from what seemed like the best of what those states had that we did not have. I think one thing with the reliable internet that some states are doing, and we should have numbered these, that would have been a lot easier, but essentially if you don't meet these guidelines, then you don't get education credit, is essentially the gist of the guidelines. Like if your internet is cutting out the whole time and you're unable to participate and that sort of thing, then it would be up to the provider to determine whether that student should get credit if they're not able to actually participate and interact in the course.
All right.
Maybe because of the internet. I'm open to another word besides reliable, but essentially I think what we were trying to get across is it's up to you to make sure your technology is working and you're able to
be able to get credit.
Yes.
So the other question was, it says something along the lines of must test their computer systems. So can they only use a computer, or can they use an iPad, or do we need to expand that, or is it limited to a computer?
I think that's a good point to discuss. I don't know. I have not tried to do something interactive on an iPad. I don't know how hard it would be. part of this is being able to interact with the instructor, which I think can look like a couple different things. Maybe you need to be able to use the chat function, and I don't know how hard that would be on an iPad. So definitely something to discuss.
People take it as far as they can take it, and there's been some that are driving to Memphis from Nashville, and they're taking their class with their,
Right, on a phone. Yeah.
driving down the road.
Not me. That wasn't me.
That wasn't you.
That wasn't me.
But I will also say, one of my agents sold a house that was on the Alabama line a couple of months ago, and internet was not accessible. There was no internet in that little Tennessee town. And there are lots of areas in Tennessee that don't have reliable internet. Yeah. So I think if you make the choice to do it by computer, then you need to go to a reliable computer source, whether it be at a library or, someone else's house or your office or something. But, if somebody's not on half the time, I don't think an instructor should give them the credit for it.
Right.
It's up to them to have the reliable computer.
Okay, so let's go back to Mr. Diaz's concern for a second. Let's say, and I like this strategy myself, is that we take what you guys provided us today, let Anna put it in a rule format, at which point it's still going to take months and months and months to get that rule changed.
Exactly.
And let us see that in that format next month. In the meantime, Jeff has said that he would like to get some feedback from local associations or education directors or executive officers. Do you have a listserv of Tennessee association executives or education directors?
Education directors.
Well, when I reached out with a listserv, it was the Arello listserv. So other than that, we don't have. Well, yes, we do have.
You probably go to TREEF and get that information.
Yeah, we do have provider contacts as far as being able to reach out to our state providers. Yeah.
So what I would propose, as soon as Anna has a draft of the rule, that we get to take a look at it, you circulate it amongst people that are in the state of Tennessee for their comments, and by next month maybe we'll have comments that will make you feel more comfortable and additional information we might not have right now. Because I'm telling you, next month that we get up here and consider this rule, there's a whole long way, and you're going to have to make decisions between now and the time that rule is finally adopted, based, I guess, on the guidelines that you're using now.
The current guidelines, I've had, most providers, most active providers are still abiding by those guidelines, and I have about 30 courses since last meeting that have sent in requests. Well, I really can't just say I approve it, but actually they don't need it anymore. So the point being there, and back to your point, that's why I was thinking that the commission may want to have something. It is still on our website now. We could continue as is, and it's acquiesced in by those providers. And that still seems to be working, but just to let you know, it'll be a while before we would have rules. That will take a year, probably.
And won't it have to be approved by the Attorney General's office?
Yes, it has to go through the
And so he announced
rulemaking.
yesterday that he's leaving. So, yes, Saturday's leaving, unfortunately. But that could cause a problem, too, with holding it up if he's real busy.
Anna's got contacts up there.
Okay, good. Good.
All right. Is there any objection from commission at this moment to ask legal to put it in a format for us to consider as a rule?
No objection.
With understanding, next month, with the understanding that you'll do your best to circulate it to affected parties for their feedback on it as well.
So, Mr. Chairman, Mr. White, is the guidelines that are in place right now sufficient for you to work through the courses that you need to work through?
They are.
Okay. So you don't need anything from us today to get your work done?
Not really. Everybody seems to be traveling on the theory that that's what they need to do, and actually I think that is, it serves the law and the rules well.
Okay. And I also want to state for the record that Anna is choosing to subject herself to the rulemaking process, that this did not originate with the commission.
I think she missed
All right,
that.
I don't know about that.
Without objection or further comment, we're going to move off this topic and on to the next. Thank you, Mr. White, and we'll look
Thank you,
forward
Mr. Chairman,
to that
members of the commission.
draft rule for consideration next month. And if we can get it as quickly as possible,
Sooner
Ms.
the
Matlock,
better.
that'd be helpful. I know you don't have anything else to do, so it shouldn't be a problem. All right. With that said, we're going to move on to the Executive Director's Report. Ms. Maxwell,
I'll keep it quick.
you take all the time.
Definitely under 18 minutes. I don't have much of an update for the commission. Open to any questions. I did want to let everybody know. I know there's been a lot of questions about the hotel that everybody stays at each month in Nashville. And starting in July, Aaron has gotten a new hotel that we will communicate to everybody. June will still be at the same location, and then starting in July, new hotel. So exciting. And then I wanted to update everybody. It's been a few months since I've talked about the Distressed County project that I'm working on, but it's finally gotten approved. We have the vendor that we're going to be working with, and so I'm now starting to reach out to the high schools in those distressed counties to work with them and then be able to offer the pre-licensing courses to any high school senior in that county that's interested in taking the pre-licensing courses through the approved vendor. And this is something we're doing with our education and recovery account, but it's also in line with the governor's Distressed County project to promote economic growth in those counties. So we're really excited, and I think it's going to be a really good tool for seniors that maybe college isn't the right path for them. It'll give them another avenue. So just wanted to update everybody that after much work, the contract had gotten approved. We have a vendor that we're working with, and so the project's moving forward.
So they'll still have to have the high school
Yes.
and the graduation and be 18 years old.
Yes, all requirements, and that's why we are. The project got delayed, so in the fall is when we were reviewing any bidders, and our top bidder ended up backing out, which delayed the whole process. So the original plan was for this to be approved at the end of 2021, and then get with seniors in January that were graduating now. The contract only just got approved last week, so we're a little bit behind. But yes, they will have to meet every other requirement. The project just allows the pre-licensing to be offered to them and paid through the education and recovery account.
Thank you, Caitlin. Any questions? Staff, everybody's okay on staff? Everything's going well?
Yep, everybody's great. My number one, Aaron, over here, couldn't do it without him.
He's been getting more people bragging on him
We
lately. I don't know
appreciate
if he
Aaron
can take
so
it much
much.
more.
It's Mr.
So,
Trek.
One item of interest I find in the written report that the director gives us each month are the number of licensees in the state. And Isaac, you remember how many licenses when you were chairman, how many people were licensed? I don't either. I know it has, but, well, at the moment, according to information we just received, there are 42,000 active real estate licenses in the state. There are 5,000 firm licenses in the state, so we're up at 47,000 active licenses, and that does not count 5,000 people in retired status. So this staff of 8 or 9 people does yeoman work keeping track of those people and people who want to get a license and people who want to complain about a licensee.
And all the people that want to transfer from one firm to the other.
It's amazing and how much more efficient this department has become. When Isaac was chair and I was with him, we had complaints all the time about how slow the process was, what it took to get transferred. It started as a new agent, and today it's bam, bam, it's great. I get no complaints like I used to. Thank you, Caitlin. All right. Next up is the legal report. Just as a quick reminder, people file complaints all the time. And they file them through a procedure that causes the complaint to head over to attorneys, these two attorneys over here. And those two attorneys research the complaints by contacting the person that was complained against and get the respondent's side of the story. And then sometimes they'll go back to that complaint again and say, well, this is what the respondent said. Do you have any follow-up you'd like to say to what the respondent said? And they gather all of this information, and then their duty is to reduce it to a fairly short summary with no hint of who either the respondent or the complainant are, what part of the state they're from, whether they're male or female, what the company's names are. It's strictly anonymous. So, back in the day, Isaac, if like today we have 57 complaints, back in the day we'd read every one of those into the record. And it caused us to have two-day meetings sometimes because we'd have just long summaries and complicated issues. Over time, we have developed a consent agenda, and with one motion and a second and a proper vote, we can approve counsel's recommendation, which you're going to give us on each complaint, in one vote. So instead of 57 different cases we hear individually, we're likely to hear 15 or 16 today, which will cause this meeting to go much quicker. So with that kind of background, I'm going to turn this over to Anna and Dennis Gregory, who's the second attorney you've not met yet, and they'll each present cases to us with their recommendation. In most cases, every once in a while they'll say, let's discuss this because they don't have a recommendation. Joe?
A note to your efficiency of Caitlin. Their efficiency has gotten tremendous in the last couple of years. I've only been here a couple of years, and the change in the efficiency of the legal staff has been great.
All right, so we've got cases 1 through 57. Commissioners have reviewed these cases. They've reviewed the narrative, and they've got the right, and you'll see that in just a second, to pull certain cases out for discussion. And so I'm going to ask for a motion to be made that is stated like this. Regarding cases 1 through 57, that counsel's recommendation be adopted on all of those cases, with the exception of these cases: 1, 2, 5, 6, 10, 11, 12, 16, 18, 20, 32, 41, 43, 44, 45, 46, 50, 52, and 55. Is there such a motion?
So moved.
Mr. Diaz makes a motion. Mr. Moffitt seconds the motion. So at this point, we're going to approve counsel's recommendation on the majority of all the cases that were scheduled here today. Any discussion? Yes, DJ.
Mr. Chairman, I, at this moment, would like to add case 14.
Okay.
So I'd amend the stated motion.
Okay. This commission is smart enough to figure out that motion now includes not approving case 14 at this point, as well as the other list that I just read. Any further cases that you'd like taken out or discussed? If not, I sense you're ready to vote. If you're in favor of the motion, please vote aye.
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 If you oppose, vote no. And that motion passes unanimously, and we've just approved about 40 cases that we used to have to read in one at a time. And it was a long day.
Thankful.
All right, we're going to go to case number 1. Joan?
I pulled this one mainly because I wanted a little bit more information, and that was, I believe you suggested monitoring it, and I wondered, what is our process for monitoring cases?
Well, like in this one, for example,
Dennis, push your microphone.
it's showing green. Is that
okay? Yeah,
that better?
I can hear you.
So, I mean, the normal process is that it'll go in sort of a litigation monitoring folder, within our, H drive, and then probably within 30 days, maybe sooner, I'll call. In this case, there's an attorney on one side or the other. There's actually attorneys on both sides in this matter, and just ask one or the other, hey, where are you all at on this? Like in this one, for example, if the motion to dismiss is granted, then the next question will be, well, did the judge make any ruling or findings on whether or not this person was acting as a realtor or a broker? And then that'll help. We can then bring that back. It'll be put back on the legal report as a represent, and it'll let you all make a decision on it at that point.
So we have a system in place, so every 30 days we check those cases that are being monitored. I guess that's what I'm asking.
And in some cases, yes, and Anna made a good point, is that we sometimes send out consent orders where that at least the respondent, usually the licensee, signs a consent order agreeing to keep us apprised of, keep us updated about what's going on. And we don't always do that. I think in this one, I can do that. That was something I hadn't really anticipated because I've opened up decent dialogue with the attorney. So, but if there was no attorney involved, that might be something that we might want to, have the person sign and say, hey, look, we're going to make this partly incumbent on you to keep us or me up to date about what's going on. That way, it doesn't just sort of languish for months on end.
But in this case, there's the complainant and respondent both are unlicensed people.
Correct. Yes. Yeah, because the complainants are just home buyers, and the respondent's an unlicensed person that we don't really know what they do exactly. And that's why if the court makes some findings of fact on their status, I think that'll help everybody make a decision on this one.
Okay, Ms. Smith, you want to make a motion on case number 1?
My motion is to accept their recommendation.
Okay. There's a motion by Ms. Franks, seconded by Mr. Moffitt, that council's recommendation be adopted. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no, and that case is handled. Number 2, Marcia. By the way, to the audience, it might be a little frustrating for us to talk about cases and you don't know what the details are about it. Anytime you'd like to, you can go to see the minutes of the Real Estate Commission. All these cases, the summaries that these attorneys have provided are included in our minutes. If you'd just like to go back and see the type of cases that we occasionally have to handle. Okay, Marcia.
So on number 2, this is one that was presented in April. It was an advertising violation. And I couldn't remember, why did we hold it over from the April meeting to this one?
Well, in that one, we had represented the original complaint to have, and in fact, I remember, I think Steve actually looked at the picture of the advertisement, and so the idea was, well, if there was a reversal on that, then we didn't want to stick the principal broker with the additional violation. So when it was represented, we found that it was still in violation. So in this one, we would still, as we normally do, would hold the principal broker.
And on this one, will you refresh my memory, was it a billboard or a sign?
Sign.
Okay, so we typically do a $1,000 civil penalty, and you have $500. And
I think that was what I had originally recommended on the affiliate broker, and a first-time violation.
Okay. I'd just like for us to be consistent on things if we can.
You've got the floor.
I'd like to make a motion that we amend this recommendation to a $1,000 civil penalty.
Is there a second?
Second.
Okay, seconded by Mr. Diaz. Again, for the audience's information, last month we found that an affiliate broker violated the advertising rules of the Real Estate Commission, or statute, I guess, the statute in this case, if it was a sign. And At that time, that affiliate was offered a civil penalty of $500. I don't know if they've reacted to that yet or not. But at the same time, all advertising is always the responsibility of the principal broker as far as review goes. So this particular case was brought by commission against the principal broker for failure to supervise advertising of his or her affiliate. So that's what we're considering at this point. The council has recommended a $500 civil penalty because that's what we gave the affiliate for the advertising. A $500 civil penalty to the principal broker. Ms. Franks, in an effort to be consistent for failure to supervise, is suggesting that it be a $1,000 civil penalty, not $500, and that's where we are at this point. Mr. Diaz, the second of that motion. Now discussion.
And so this is for failure to supervise. It's not an advertising.
Correct.
Okay, thank you.
Yep.
Steve?
I think since I'm the only one that saw it, in my opinion, it was not egregious, so I'll let it go at that. I'm going to vote no.
Well, it was either compliant or it wasn't.
Correct, but
So was it compliant?
So, without going too far into it, occasionally you'll hear these commissioners challenge each other, which is what you want to have happen. We like everybody up here. We get along with them fine, but sometimes somebody from West Tennessee might think differently than somebody from Middle Tennessee or the interpretation of the law. So at the moment, unless somebody wants to amend or put a substitute motion on the floor, it's a $1,000 civil penalty for failure to supervise is the topic we're voting on. Anybody want to amend it? Offer a substitute? If not, I think we're ready to vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no.
no.
And that motion passes on a 6-aye vote with 2 no votes. Commissioners Gwynn and Ferris voted no.
May I say something?
Yes.
Just as
Get real close.
a word of information, because I'm guilty, my company logo is such and such. So we just need to be really careful with our advertising that a company logo is not the name of your company. Correct?
We don't make any blanket statements about advertising.
Excuse me.
Your principal
So
brokers you need to make sure you comply with the rules.
So just as a principal broker, I'm saying I need to really pay attention as a principal broker, not as a commissioner.
It's not up to the real estate commission or staff to say that is legal or not.
Not like, but we
It's
need to
all
be
on the
really
principal
careful.
broker. Correct.
Need to be really careful.
Joe?
So, John, since you've done a great job of educating the crowd today,
Yes.
you might want to speak to why Steve's the only one that saw the picture.
Yeah, so in an effort, that's a great point, thank you. So we're going to have one of those today, too. But remember, the purpose of counsel is to present the facts without giving us any bias about who it is, where it is, what the company is, male or female. But on an advertisement, when it's close or when it's questionable, legal will ask for one member of the commission to take a look at it, and that member of the commission will typically be from some other area of the state. And that commissioner will look at it and give his or her opinion of what he or she has seen on that sign, and then not be able to vote. It's strictly to give us his or her perception of what that sign looks like. You'll see that later today. We've got one of those coming up. And sometimes it's really very obvious, and sometimes legal goes, man, it could go either way on this, and that's why they ask commission to take a look at it. Thanks, Joe. That's a good
So
point.
Steve won't be able to vote on this one since he saw the advertisement?
Well, it's a different topic. This is failure to supervise.
That's true. That's true.
It's not the advertisement.
That's true.
And he's already voted. As a matter of fact, he voted no. And we're done with that topic. We're on to case number 5. Marcia?
Number 5. Oh, okay. So number 5 is a wholesaling case where they say they're assigning their equitable title to real property. And so our attorneys have this one down. They didn't give us a recommendation. They said that we should discuss it. So, and correct me if I'm wrong about this, but we got an opinion. We kept having wholesaling questions coming before us. And so we asked, so that we could be sure about this, for an opinion from the Attorney General's office, and we received that opinion. That's not the same thing?
No, we found a court case
Oh, okay.
on point from one of our summer interns, actually, last summer.
That's right.
That's found a case in support that stated wholesaling, if it was not to be considered unlicensed activity, it would go against like the whole meaning of what being a real estate agent would be. So, yes.
So there's lots of people out here that call themselves wholesalers that don't have licenses. And and that's the case in this one, actually, even though they didn't use the word wholesaler, is that they say they're signing their equitable title to the real estate. So I'd like to make a motion that we, what would that,
let's say, first of all,
Okay.
that court case found that if you are trying to sell the contract, you have to have a license.
Right.
Previously, we didn't believe that was the case, but the court case now says these wholesalers can't just go out there and.
They have to be licensed.
So you're likely thinking maybe about a fine for unlicensed activity.
Yes. Okay.
A civil penalty. We don't call them fines.
Right.
We call them civil penalties.
So I'd like to make a motion that we find this person as doing unlicensed activity and give them a civil penalty of $1,000.
Is there a second?
I'll second.
Mr. Moffitt seconds the motion. Mr. Diaz.
Counsel, does it make a difference that the contract says that it's for assignment and not for sale in this case, or does it still become unlicensed activity?
That's a good question. That's going to be there if they don't agree to to be captured in a consent order. If they don't agree to that, that's what's the argument's going to be. And that may facilitate a little bit more.
So on this contract, is there an initial line at this where this language appears that says they've seen it?
We don't have it. No, all that they did was provide. There was no contract. Neither party provided any contract. It didn't provide any listing. The respondent said that they've posted this somewhere. I didn't see it, but it will probably beg some discussion if they don't agree that.
That would be the
Just
next
in
step.
Arizona, this is someone who's doing business, not physically in the state.
Okay.
So,
All right, so we pretty much have this court case to stand on then.
right, that's the only thing we have right now.
So, yeah, I guess that's hypothetical. Okay, thank you, Mr. Chairman.
Joan.
Yes, I pulled this one also, and I was wondering if you saw any of the advertising that was done. You did not
No.
see that?
It was a pretty bland complaint.
Okay, so the motion on the floor is to offer this respondent a $1,000 civil penalty for unlicensed activity. That's the motion. We've got a proper second to it. Any other discussion? Steve?
Question. Dennis, I'm struggling trying to understand what this respondent told you that's in quotes. Exactly what does that mean? Do you, assigning equitable title to real property, which is granted via the bilateral purchase contract as seen in the disclosure statement. So you've not seen any of the contracts or any of that?
No, they're just referencing. It would have been, if they would have attached it, might have had a different recommendation in this, or might have made a recommendation in this particular matter. But this was just something she pulled or he pulled from somewhere, or it's just their opinion that they just pulled from their head and stuck it in the complaint. So literally, we have a complaint summary form. That's what the complainant sent in, and we have a response form, and that's what the respondent sent in with no supporting documentation. So right now, it's just sort of a.
And this again is a nationwide problem. that I have seen and heard discussions at Arello. One big, huge thing, I don't know if you have it in Memphis, but in Nashville, we're always having these people that come in and they teach you how to flip houses, and they sell you books and they sell you tapes, and they give you these instructions on how to get around law. So, I think at this point, if this is all we've got, that we at least need to go forward with the unlicensed activity because they're not licensed.
Jeff?
Were you, and I lost my train of thought there, but were you able to tell in anything that they, I'm sorry, Mr. Chairman, I lost my train.
That's all right.
Did they give you any proof? Is that what you're trying to ask?
Trying to read his mind.
Yeah, I'm reading.
Here, for the benefit of everybody, maybe just give a real recap of why this is unlicensed activity. It's obvious, but for the audience, for everybody, just.
Well, based on a recent court decision which influenced the legal department, the Tennessee Department of Commerce and Insurance significantly, the court ruled that you had to have a license if you had a contract and you're trying to sell it. The equitable title didn't come into play. The court said you had to have a license, and that's the genesis of it.
Yep.
All right, I think we're ready to vote. The motion, once again, is to offer this respondent a $1,000 civil penalty for unlicensed activity. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. And that motion passes unanimously. Number 6. Is that yours, Joan?
Yes, it
okay.
is. I was on a roll.
I've got number 6 down, too.
So. Oh, you want to go first?
No, I want you to take it.
I had a question. It was said, she says this was later corrected in the MLS. Is there a time frame that correction was made? It was on square footage. She originally said it was one thing, and then it was something else, and a complaint was filed on that. So I'm just wondering if we have a time frame of when that change was made.
No, and of course the issue or a number of homes. So this is just one home that she's referring to, and there's no stated time frame in which the MLS was corrected. Presumably, maybe 30 to 60 days. Could be longer. I wouldn't think it'd be shorter than that. But we don't know how long it remained. It was 2,200, and then it should have been 2,400.
And it's an HOA complaint, which we don't have jurisdiction on.
No,
isn't it?
No.
Well, there's an HOA element to the complaint,
yeah,
but we would still have.
Here's how I saw the case.
Okay.
This is a square footage, a measurement issue, and bottom line, the complainant says the respondent is misrepresenting the size of these new houses. She's saying maybe they're 2,800 square feet when in fact they're only 2,200 square feet. The respondent's defense is she was only representing what the builder told her to represent. In my mind, that's not a good enough answer. I mean, if somebody tells you you've got the wrong square footage down, then maybe you owe it to yourself, your company, and the public to go out there and either get a set of plans and get the square footage off that or go measure the dang building. And this woman chose not to do that as far as I could. This licensee, don't know if it's a man or a woman, chose not to do this.
She.
Does that say she?
Mm-hmm.
Okay. So, shouldn't say she, should it?
That person.
So that was my problem with this case, is that they were saying whatever the guy tells me is what I'm going to represent, and I don't think that's protecting the public.
I don't think it was either. I'm going to agree with you, but I also think that we have an obligation when we have correct information to put it to the public as soon as possible. So my question was, do you know that? That's why I asked, is there a time frame? If you wait 30 days before you change it in the MLS, that's misrepresentation.
Well, the MLSs are maintained by the real estate associations, though, not by the commission.
I agree with part of that.
Yeah.
I will say I don't think anyone made an offer on the house while it was listed at 24, or rather at 2,200. So that's why I think the time frame was probably,
It's just bantering, really, isn't it?
It is. I mean, these two parties have a problem with each other that's more than just.
So one filed a complaint.
Okay,
Right.
so the floor is open for a motion at this point, and that motion may well be to accept council's recommendation or some other motion, if anybody would like to speak.
Joan?
I'm going to make a motion that we accept council's recommendation.
Second.
I've got a motion by Ms. Smith, seconded by Mr. Diaz, that council's recommendation be adopted. Discussion? Are you ready to vote? Let's do it. Those in favor of the motion vote aye.
Aye.
Those opposed vote no. And that motion passes unanimously. Number 10, 11, and 12 are all related. Right, Dennis?
Correct.
Okay, Marcia, you want to go?
Okay, so on number 10, if you look at paragraph 4, it says, the respondent says he recognizes that the referral fee should have been paid directly to the licensed real estate brokerage entity. So that to me is a person saying they know that they did it wrong. So they paid a fee to someone who wasn't licensed. Is that correct, Dennis?
Well, I mean, either he mischaracterized what happened, because when I look at the documents with the names being similar between the let me get the parties right, between the brokerage entity and the purchasing entity and then the affiliated brokerage entity, I could take it that there actually was no money that was paid to the person who shouldn't have received it, that it was just a mistake on the compensation agreement. However, if they paid it to someone if what he says is true, that he hasn't mischaracterized it, then yes, he.
So what they're saying is they reduced the commission, the buyer's agent reduced the commission and gave their commission to the seller, to his buyer, his or her buyer, and so at closing, this amount was taken off of the sales price.
No.
No.
The money was actually given to the buyer.
Right.
Yes.
Oh,
Yeah.
okay.
That's
Okay.
why I pulled it.
So it was cash to the buyer.
And
So
legal
you can't do that.
Well, legal says, and I understand it, that the names were so close between the brokerage and the buyer, they were related entities with very similar names,
Right.
that it was an honest mistake. I mean,
That's kind of how I saw it.
So are you saying the title company made the person closing it made the mistake?
Right.
Not the agent.
Right. They got the names. They were the names were so similar to begin with that they put them in incorrectly. And I think it was just really out of an abundance of caution that this complainant, the listing agent, lodged this complaint.
So
He wouldn't sign it. Now, we don't know what the rest of the story is. Did they eventually get this resolved, and then the listing agent was okay with it and signed it, and sort of everything was put to bed? But initially, he wouldn't sign the compensation agreement.
Okay, I'm confused just a second. Compensation agreements are usually filled out with the offer.
Broker to broker.
And then we're already to the closing, so the compensation agreement should have been filled out prior to closing. So, and my other question is, why wasn't that change made at the closing?
Because a lot of realtors don't go to closings anymore.
No, but they get a copy of a settlement statement.
True.
They get something that
After
says.
the fact. There's a lot of people just picking up checks in the closing statements now.
all right, so the question on these three cases, 10, 11, and 12, boils down to the fact, do you think it was an honest mistake? And if so, do you want to offer a penalty for that honest mistake, or do you think it was a flagrant, intentionally done, and a clear violation of?
I would like to know who cashed the check.
Yeah.
I doubt if you're going to find that out today.
Well, the buyer, it went to the buyer, correct?
Well, presumably, yes. But that's the thing we don't know was the
So
cash checked?
I'd like to make a motion on
cash.
number 10 and 12, if I can do them together. Is that all right?
That's perfect.
That we accept council's recommendation and close it.
Okay, there's a motion. Who seconded that?
I will.
John Moffett did. Thanks, John. The motion is to accept council's recommendation on cases 10 and 12. We still
I
have
say this?
11 to go through.
And I started to say, do we still want to go over 11?
We'll come
Because
back
she
to it.
pulled that one. I didn't say 11.
I pulled it.
Oh, you pulled it. Okay.
We'll go on. Let's
Okay.
get 10 and 12 out of the way.
Okay.
Any further discussion on 10 or 12? If not, those in favor of that motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. Number 11 is the same set of circumstances, but it has to do with the principal broker.
Now, it does say he wasn't the broker at the time
Correct.
of the transaction.
So it's hard to penalize a principal broker who wasn't principal broker at the time this happened.
Right.
It's hard.
So chair's open to a motion.
I make a motion that we accept council's recommendation and close that one also.
Second by Mr. Begley. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. Thank you all. Number 14, DJ.
Thank you, Chairman. This is a case in which a seller has planned to sell a house, had not one listing agent, but two listing agents, two co-listing agents. And there was an agreement in the listing agreement, understanding in the listing agreement that the seller wished to have more time after our closing for which to possess the property. Offer was received, conveyed to the seller signed, and then it came to light by one of the co-listing agents in a conversation that sounds like, oh, by the way, the 30-day occupancy period that you described to us is not included in the contract. So they realized that. They sought to make amends by it. They owned up to it, it appears, which is what the right thing to do as our colleagues. You'd want our colleagues to do that. And yet, the buyer didn't buy it. The buyer feigned legal action, which not uncommon, and we hear that from time to time as practicing brokers. Seller didn't sell the property, got out of the deal. And so on one hand, I commend the respondents for offering to reduce their commission, to trying to make it right. But on the other hand, I think at least a letter of instruction, maybe a letter of warning, but I'd open up to the commission. We could close it, but not one but two of our colleagues missed a very important detail by their client. And if it had been handled correctly, maybe the house would have sold. We can't say that, but I think it needs to not, I don't think it ought to go without them knowing that we're aware of what you've done, and way to go, I guess. But anyway, that's all I have for that.
Well, you've talked enough to convince me that whatever motion you make, I'm going to vote for. Okay?
Well, and they were first licensed in 1984.
Right.
So they should have had enough experience to know not to leave something as significant as that out.
And mistakes happen.
Yeah, of course they do.
You know, I've made mistakes and will again, probably.
So what's your motion?
Anybody else have any thoughts about that? Joan, do you have any thoughts?
I agree with you.
I think a letter of
I agree.
instruction is a good way to go too.
Yeah, since they thought to try to fix it themselves, I just think that they need to know we're aware.
So what would you want counsel to say in this letter?
Well, it'd be based on reasonable skill and care, I think. I mean, I think that if you're...
Yeah, that's
and there was an omission. I think that facts support that they just didn't see that 30 days was not included in the offer.
They just missed it.
So, yeah, I move that we submit to these two respondents a letter of instruction advising to take reasonable skill and care in each of their future transactions.
There's a second to Mr. Ferris's motion.
Second.
Ms. Smith seconds that motion. Any further discussion? I sense there is not. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. Thanks, DJ. Number 16. Joan, is that you?
That's me again.
All right, good.
This is a situation where someone gave the buyers keys early, and they took possession of the house before the closing was completed. It made me groan too when I read that. So my question is, who gave permission and the keys to the buyer or gave them access to the home prior to closing? Or before I understand that one of them had closed, the buyer or the seller, but it has not been completed. And the buyers, I believe, go by the house and find them moving in.
I'm just reviewing
That's fine.
my own narrative.
It says, as the buyers were moving in early, the respondent says he did not tell them they were free to start moving in. He says the buyers clearly got the impression after they wired the money that it was okay, although the sellers had not signed their documents.
It's a fair question. Who gave him the keys?
Who gave them the keys?
That's the bottom line.
That's the bottom line. Who gave them the keys?
Keys were either still in the lockbox or the listing.
Somebody has to give them a code or some
Right.
way to get in the box.
I think this is obviously a concern, the key and who gave them who and when who could access. But there's also a very important discussion to be had about, at least on the consumer standpoint, is how they agreed upon the commission structure. There was a purchase price of $800,000, and to try to make sure that the buyer's agent had another % of commission, they agreed amongst themselves to up the price to $808. And the seller of the house is like, wait a second, that's going to be reported as what I'm making. Income. And
I agree. There were two issues there.
so at least for that issue, I would say there needs to be some type of reasonable skill and care, or look after your client's money. I don't know what the...
So let me ask this question, Joan. How important is it for you to know who gave them the key? Is that, if you know that, you know what to do?
That is important because we should not be giving keys.
I got it. So once you know that, if you know that answer, you'd be prepared to vote.
Yes.
So would you like to put this off for 30 days and let council see if they can get you that answer?
Yes, because I would like to know who we need to give a civil penalty to.
So I'm going to assume that's your motion to defer this for 30 days to get additional information. Mr. Diaz
Second.
seconds that motion. Any discussion?
I can't find it.
Now, that does not preclude a discussion on the issue that DJ brought up as well, but the case, if this motion passes, will be heard next month with hopefully additional information. Let's vote. Those in favor of deferring for 30 days, please vote aye.
Aye.
Those opposed, no, and that motion passes. Was there a no somewhere? I said no. Oh, okay, that's good. I'm okay with no votes. There's 7 aye and 1 no vote. Mr. Ferris voted no. All right, number 18, Joan.
Oh, here I am again.
Stay here.
I had a question. Let me think where I am now. Is the listing agent buying and are they selling their own property, or whose land are they selling? I was confused a little bit on that one. You received a complaint that says his client received a letter in the mail from the respondent offering to buy his property.
So,
but he also says he's unlicensed.
Well, the person that's making the offer is unlicensed. The listing agent is representing the seller, and the seller got this solicitation from this unlicensed person who says, "Hey, I'll buy your house for, or I'll make you an offer."
Okay.
So he's asking the buyer sell for himself?
Yeah.
Or herself?
Right.
So you don't need a license for that.
No.
And the website doesn't communicate that they're offering to represent buyers or sellers.
But he also says, they offer to buy land, although they sell land as well.
They buy and sell. So, I mean,
they selling their own land, or are they selling land for someone else?
It's their own land.
Okay.
All right, so with that explanation, Joan, are you comfortable with council's?
I am.
That's your motion.
My motion is to accept council's recommendation.
And Mr. Diaz seconded that motion. Any further discussion on case number 18? If not, let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 20. This has to do with a for sale sign that doesn't have the company's name on it. And council's recommendation suggests a civil penalty of $500 for advertising violation, and also suggests that a complaint may be opened against the supervising principal broker. And so that's the part I want to focus on. I'm okay with the recommendation of the $500, but does this commission, as we've done in the past, feel the need to open a complaint against the principal broker of this affiliate who had illegal advertising?
Yes.
Okay, and so the chair would entertain a motion to that in that respect.
I'd like to make a motion that we open a failure to supervise against this principal broker.
Is there a second?
Second.
Second by Mr. Diaz. Any discussion? Those in favor of that motion vote aye.
Aye.
Those opposed, no. And that motion passes unanimously. Number 22.
Now, what are you going to do, though, about,
Yeah,
Back up.
my fault.
The sign.
So let's go back and get council's recommendation related to the affiliate broker, which was a
So-
$500.
civil penalty of $500. Mr. Diaz makes that motion.
No, well, I got a question, but if you want to put a motion on the floor, that's fine.
You put it on. Joe seconded it. Now you can discuss it.
Okay. Do we know, it says property not technically for sale.
I couldn't figure out what she meant by
that's
that.
a new one.
So, see, because when I hear that, I feel like it's just somebody driving around neighborhoods putting signs in yards.
Right.
I mean, it's,
And the thing is that there was no, was this the one where, there was no picture of the sign provided with the complaint, which is a little unusual for these advertising complaints, but the respondent agreed, yeah, that's what it said, and in fact, I wasn't selling anything, which is why I just had my name and number, but then that's why I made that statement, then why are you putting signs?
man.
Presumably the person or the owner had given them permission. I don't think it's a sort of thing where someone just walked out of their home and there was a sign there, but...
I mean, the representation agreement, though, authorizes the agent to put a
Right.
sign in the yard.
Right.
So
And do we know that it wasn't their own
argument.
yard?
it wasn't their own yard then?
Do we know it wasn't the,
It says
I
in
didn't
a
get
yard.
that impression that it was their own yard. I think that it was somewhere
could have been their
where
mama's, though, just to get their name out
It
there?
was an invitation to pay me to move. Is that what this is? I don't know.
So some of y'all might want to try this technique, the sign. This is what the sign said. This is a sign without a real estate company name on it. It says, not technically for sale, but make us an offer. For the right price, we'll change our mind. Put that on the sign, and then they put the contact number is a licensee's phone number. And so at the moment, we're debating council's recommendation that a civil penalty of $500 be assessed or offered to that licensee for
And we already think that there's a
Advertisers.
violation because we found the principal broker in violation already.
Well, no, we haven't. We're just going to open a complaint against the principal broker for
No,
failure
I
to
thought we already
supervise.
voted on that.
We did. It's open a complaint. We haven't found it.
Okay, open okay.
So, Mr. Chairman, I'm going to change my motion here.
Okay.
I'm going to accept council's recommendation for $500, but I'd like to add a education requirement
Be my guest.
for the core course to be completed within 160 days and not counting towards the continuing education.
180 days?
180. Sorry, my math is bad.
So what is the course that you're suggesting?
Core.
The
core
core
class.
course,
Yeah.
which you're going to have to take anyhow.
Yeah, but
every
it's not
2
going to
years.
count towards their CE.
This won't
He
count
has to take
towards
it
it.
two
That's-
times.
So we're going to get to take it twice if this
Yeah.
passes. Okay.
Seem to need it.
All right. We're going to talk about Mr. Diaz's motion, which is to offer this affiliate broker a civil penalty of $500 and a requirement to take the core course for no credit within 180 days of him or her signing the citation. That's what's in front of the commission at this point. Any discussion on that? All right, let's vote. Those in favor of that motion vote aye. Aye. Those opposed, no, and that motion passes unanimously.
Chairman, I
Thank
have
you,
a
Jeff.
question.
Yes, sir.
Before moving forward. There was a case 21 I had in my notes to discuss. We have now voted to accept council's recommendation on that. It's not on our list. Is there any way to go back?
There is. Make a motion to reconsider case 21.
I move we reconsider case 21.
Is there a second? A second by Ms. Franks. Any discussion? This has to get like a 2/3 vote to pass. Those in favor of the motion vote aye.
Aye.
Those opposed, no. And so we're about to reconsider case 21. Mr. Ferris, tell us what's on your mind.
Thanks. This one is another one.
Counsel,
Council's laughing at us.
You think the chair doesn't know parliamentary procedure or something? Is that? Carry on. Thank you.
Yeah. So
Mr. Ferris.
This case is involves a complainant, the seller, a respondent, again, as a co-listing agent. So two of our colleagues here in Tennessee were going to represent the seller, and they were first licensed last year. So not very experienced, I might say, or let's just say they haven't been licensed long. And there was the complaint is the seller says, hey, I told the respondent that I would accept no less than $280,000. A cash offer came in for $250,000, and the respondent, and so the complainant said, I don't want to sell for less than $280,000. The respondent gave a response and said, well, we spoke with her verbatim, and it was agreed upon, and she signed the document. And so, on one hand, I'd like to, I could accept counsel's recommendation that, hey, this complainant is, I'm going to presume, is a grown person. They're responsible for what they do. They signed the document. They sold the property. On the other hand, you've got two professionals, again, representing the seller, and we don't do anything just by verbatim or by a phone call. And I know she signed the document, but I just feel like I had in my notes to issue a $1,000 civil penalty.
That's okay. Is that your motion?
I just want to check the tenor of the.
Oh, don't do that. Make a motion, and we'll discuss it. Go with your gut.
Yeah, I do. I think the motion, I move to assess a civil penalty of $1,000 for failure to exercise reasonable skill and care.
All right. Is there a second?
I'll second just for this.
Okay. Now it's on the floor. Mr. Diaz, second to that motion. Jeff, do you want to speak to it?
Well, I'll defer to Commissioner Begley if he's got a question.
I don't understand what they did wrong.
Well, I learned many years ago from this lady who had been a realtor a long time, if it's not written, it's merely conversation. This was merely conversation, and it didn't get written, and the seller signed it.
Well,
I don't think it would hold up in court.
Well, I've had a lot of clients that tell me, I'm not taking a penny under $250.
Yeah, there's nothing wrong with that.
And then you're like, well, here's $220 cash, and they're like, I'll take it.
Sure.
You've got to present it.
Yeah, I mean, you have to present it, and they took it. I mean, they didn't disguise the $250. It says that it wasn't, she just says that previously she said she only wanted $280, but everybody wants more until the money's on the table. Mm-hmm. So, I mean, I don't understand what.
That's a good point, Joe. That's a good point.
Oh,
I've seen that too.
Are you speaking to the motion or against it?
I'm against it.
Okay.
Other
comments?
Am I missing that it closed?
Yeah, she sold it. It was sold.
All right, I'm missing that.
Yeah, she got $250,000 and she wants $30,000 more. Because I'm not opposed to getting $30,000 more, but you signed
It doesn't say that it
I'm not entirely
doesn't say
It does
certain.
not say it closed.
The complaint sort of trailed off. It's not conclusive. It's sold. I mean, I think
okay.
she's well.
It's merely
she
conversation.
claims she claims she will not sell the house
Right.
despite the buyer's threat to file suit against her. But yeah, as I'm rethinking of this,
Sloppy.
yeah, it's just sloppy. But yeah, you're right. I mean, I've seen that happen where, and Marshall, you're correct too. If it's not in writing, it is just there. So I withdraw my motion.
Second withdrawal, Jeff.
Yes, sir.
Okay, there's no motion on the floor at this point. Steve, do you have a comment? Is there a motion?
If he's withdrawing, I'm good with that.
Okay.
I make a motion that we accept council's recommendation and close.
Second.
Second by Mr. Moffitt. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. And the motion carries unanimously. Number 32.
This is the sign.
Get to it.
Well, this is the one where we need a commissioner to review and add.
Yeah, so
What grand district?
let's do
Style
this.
guide.
This is a very short complaint. I can't, Dennis, would you read this into the record so people know what's going on here on this one? Number 32.
So the complaint is anonymous. The respondent is an affiliate broker. The complainant says the respondent's advertisement sign is not in compliance with the commission's rules. The sign displays the respondent's name in larger size than the firm's full name. There are two letters, however, that are equal to or larger in size than the respondent's name being the person who's on the sign. The respondent says his sign is in compliance as the two-letter branding is larger than his name. He claims his firm has a style guide, and that's just what he calls it, and I put that in quotations, that he followed. The respondent appears to have followed the reference guides. What I'm saying is he followed what's in the guide, but the question becomes, was the guide correct? And then, of course, is the sign correct?
So at this point, counsel is asking one of us to take a look at the exhibit, and typically counsel wants that person to be from some other area of the state than where this sign, where the complaint originated. So middle, east, or west? Dennis, who needs to take a look at it? All right, so Steve Wynn did it last month. We're going to get somebody else.
Do it east then.
Joe.
Joe?
Look at Joe.
This guy. Joe Begley's about as far east as anybody can
Yes,
be.
he is.
So what's going to happen is Joe's going to count or talk to Dennis for a moment. Dennis is going to show him the exhibit, and then we're going to ask Joe to tell us what he sees.
I love that, though. I followed my firm style guide. Oh, well,
I
the
know.
firm style guide. I guess.
My note said I'd like to see that style guide. See where they
Well, in that case.
How long did I?
We had a long drive, but it's already afternoon in Knoxville. Joe's got a long drive. I think we ought to take us a break. We got to
Not unless someone needs to.
go on our own.
We don't have.
Assuming that the style guide is a reflection of the actual sign.
Well, if we don't have the actual sign, then how could we find someone guilty?
Well, he did say he followed the style guide. So
But we don't recognize the style guide.
I get another chance, this didn't count.
Can I make a motion?
So we don't have
Not
the
yet.
sign.
Let me see.
can council obtain the sign?
Well, we can, much like we did with previous,
We should have asked for the sign.
we can defer this until June.
That was my motion.
Yeah.
Ms. Smith makes a motion this case be deferred until the June meeting, seconded by Ms. Franks. For the record, Joe Begley will get to look at that sign next month and won't get to vote next month either. All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. Number 41, Joan.
Let me think where I am. This was about earnest money. And I guess my question was, because this is not a typical situation in my market, why did the seller put up earnest money instead of the buyer?
What?
They really want to sell the property.
The respondent is the buyer's broker. Wait a minute, maybe I misread it.
They
Excuse
signed an
me.
authentic sign that they didn't mean to sign.
Yeah.
That's what this one is.
I apologize. I made a mistake in reading that.
No, you didn't make a mistake. You studied it too hard. So do you
Well,
would you like to make
sometimes you're reading
I
a
know.
respondent complaint, and I just want to put
Just
When
think-
you're
John
reading
and
60
John.
cases, they run together.
Just think if you had to write this, not just read it. How they do
Well,
it.
they get paid the big bucks.
Yeah, I'm going to make a motion that we accept council's recommendation.
Second.
Got a motion by Ms. Smith, seconded by Mr. Diaz. The council's recommendation on case number 41 be adopted. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed,
Aye.
no, and the motion passes unanimously. 43, Joan.
Oh, here we go again. This one, I have a question. Should a complaint be filed against the broker who gave this advice to not disclose? Let me go back and see what he gave him advice not to disclose.
Well, he advised him not to, that he didn't have to disclose his issue pending with, excuse me, with his securities license.
Okay.
So, because his, the license that we're concerned with, of course, deals with real estate.
Right.
Separate from securities or insurance. And we don't know, of course, there's no specific name, and I don't even know, if we could pinpoint who.
Who was giving him the
I mean,
information?
possibly
not
the
disclose.
respondent, could say, yes, this person in my firm or at my firm told me this. I think my rationale for bringing this back to you all was that since we, and understand the commission is in no way bound, or it doesn't even have to be influenced by what an ALJ administrative law judge has said about the 6-month suspension with no penalty, but it's at least somewhat worthy of discussion. The FINRA action, of course, is behind us, so now we're just looking at, we've had one division within Commerce Insurance that has taken this licensee to through their process, and an ALJ has ruled a 6-month suspension was sufficient. So the previous stance that this commission had was a revocation. So you take all these things into consideration, possibly, again, just a recommendation from my standpoint that a 6-month suspension might be appropriate if you sort of take into account everything that we have here.
Was it revoked by commission action, or was it revoked because he didn't inform the TREC about his?
The recommendation was to revoke because he didn't inform on his initial application. He didn't mention anything about his securities issue, and
Right.
that
So
has
statute-
now.
And the commission voted to authorize a formal hearing and issue a consent order for revocation.
Right. And that
So
was
the new
bef-
information is that an
He didn't
administrative law judge now says 6 months instead of revocation.
correct.
But
So now it's back to us to authorize
You
a
could
full
still,
hearing or not.
you could still sustain your previous decision to offer him a
But
consent order with a voluntary revocation, or you could change.
But the revocation, at least in my recollection, if they don't inform within 60 days, the revocation is automatic and statutory.
Well, that would be for like a
No?
criminal conviction for someone who's already a licensee. But this was just on an initial application.
And the problem with this one, it was opened in July of 2021. So this person is still doing real estate, correct? They're out here. So we need to get on with it.
Right.
Correct. I mean, they are
Who
licensed.
pulled this one? Who pulled it? Joan.
Question.
Go ahead, Steve.
So, Dennis, the revocation, so this was a guy that had a securities license as well as a real estate license.
Right.
And he had a FINRA problem. He didn't check the box correctly on his real estate license form, correct? He's now gotten suspended by not the Real Estate Commission, but by FINRA for 6 months.
Well,
right?
by the Securities Commission,
The Securities Commission.
as part of the Tennessee Department of Commerce and Insurance. They're
Correct.
another division with it.
Correct. So his suspension, so what you're wanting to do is mirror the suspension time frame, because when we revoked it, that goes for how long? 2 years?
No, revocation.
I mean, he's got to wait to apply again for a period of time.
Well, there is no revocation.
Yeah. So let me clarify the timeline just a little bit. So the respondent initially applied for licensure. They were granted licensure. Then upon their renewal,
Yes.
they checked the box to let us know about the FINRA action. They didn't disclose it upon initial application because they were told by an individual that it would not be considered a disciplinary matter. So that's why it came to the commission in the form of a complaint instead of before the commission in the form of an informal appearance, as it would have at that time. And so during that time, their securities license went through the same kind of procedure that they had, and their securities license was suspended by an administrative law judge for 6 months. This commission decided to revoke their license based upon the fact that they did not disclose the FINRA action at the initial application
Because
portion.
had they done that, they wouldn't have received a license.
It's possible.
They
But-
come before us.
Right, they would have had to come before us. But the argument is that they were operating off of incorrect information.
Which goes
So
back-
the reason it would not be the immediate 60 days that Commissioner Diaz was speaking of, he's talking about 6213-312F, is because that this action did not happen during the life of his license. It had already occurred prior to being licensed, but the actual action of what happened pending happened afterwards. Does that give you more information?
Okay, so I go back to my question. In this, it says, respondent states he was informed by someone at his brokerage that he should answer no to the application question. So I guess my concern was, did the broker tell him to say no?
We don't know who told him. I mean, it could have just been a fellow affiliate.
It could have been no one.
Could have been no one.
Right.
And under 6213-312F, it says whenever a licensee pleads guilty or is convicted of any offense enumerated in this chapter, the licensee must within 60 days notify the commission of that conviction and provide the commission with certain certified copies of the conviction. So it didn't happen within that 60 days. It happened before. The licensee shall automatically be revoked 60 days after the licensee's conviction unless the licensee makes a written request to the commission for a hearing, which they did not do.
Has he made a written request?
No. And it doesn't apply because it's not a criminal conviction. Because the FINRA action's not a criminal matter, it's an administrative matter. And what happened to him with the securities division of Commerce and Insurance is also not a criminal matter.
Right. So in the informal appearance capacity, when we have individuals come before us, such as Ms. Kimberly this morning, that was because of the rule in 1260-01. So it talks about criminal convictions, but it also talks about any disciplinary action from any state, federal, or local occupational licensing body. So since she held a nursing license and she had an infraction, that's why she had to come before the Real Estate Commission. So if this respondent had told us about this because they hold a securities license, and I would make the argument it falls into that category, they would have appeared in an informal capacity. But the notification that's mentioned in 6213-312F exclusively applies to criminal convictions.
All right. Thank you for that explanation.
So we've had a prior decision to authorize formal hearings, and now the new recommendation from our legal team is authorize a formal hearing and authority to settle by consent order to include a 6-month suspension. I would make a motion that we accept council's recommendation.
Second.
So you're in favor of a 6-month suspension at this point?
Authorize a formal hearing and authority to settle by include a 6-month suspension.
Is there a second to that? Second by Mr. Moffitt. The motion is to accept council's recommendation on case number 43. Further?
And when they have the formal hearing, it could be, if we find it, it could not be as egregious, or it could be more egregious. So it could be a revocation or not.
But if he agrees to this, then there will be no formal hearing.
Authorize a formal hearing.
That's just
Settle, okay.
the consent order would absolve the need for a formal hearing.
All right, ladies and gentlemen, let's vote. If you're in favor of the motion to accept council's recommendation on case number 43, please vote aye.
Aye.
Those opposed, vote no. I've got one no vote. Mr. Bagley votes no. All right, Commission, we have 6 more cases. What's your pleasure? To keep working through them or to take a quick break?
Let's push through.
Let's go. Let's work.
Break?
No.
Okay, if you need to go individually, please feel free to do so, but we'll keep working through. Number 44, Marcia.
Okay, number 44. This was the case that was originally opened in March 30th, 2020. So it's now over 2 years old. This was a case of a licensee was showing a property, and the property had cameras in it. And the licensee is on camera going through drawers and medicine cabinets in the bathroom, in the master bath. And when the seller gets home, the narcotics are missing from the drawer and the medicine cabinet. So we originally, the original decision was a consent order with a 6-month suspension of the license. And we had a new recommendation that was 3-month suspension and a civil penalty. And now we've got another new information that this person thought that they didn't have to do anything about the 3-month suspension and civil penalty of $500 because they went before, obviously, their local board, and they told the local board it wasn't narcotics, it was Excedrin. And so their local board had them take the C2EX, the NAR course, and so they thought they were done with it. And so they didn't know that they still had this lingering up here in Trek, which, that's what, I don't know why anybody would say that, but that's their excuse at this point. I just know this. They are on film going through medicine cabinets and drawers in a master bath, and narcotics are missing. And now they're saying it wasn't narcotics, it was Excedrin. So, I mean, give me a break. And our new recommendation is to discuss. I think we went very light on them and gave them a 3-month suspension and a civil penalty of $500.
6 months.
But when we first said a 6-month suspension of the license. And I don't know why they didn't accept it, except I know these people that are on suspension are still out there working and going through other people's narcotics and that don't have cameras. So at this point, I see no reason to say there is no oops that I'm going to accept in regard to this case. And I would like to go back to the original decision that we made, and my motion would be that the commission issue a consent order with a 6-month suspension of their license.
Is there a second to that motion? Second. Mr. Moffitt seconds it. Now, a question for Dennis. I don't doubt Ms. Franks for a second, but Did she state the facts correctly as far as?
Well, I guess clean it up just a little bit. There's two incidents. There's the one that the respondent, the principal broker, opened this complaint and said, I've got an affiliate broker who was caught on camera, like Marcia was explaining, going through the cabinets. So that was one instance. Then there was a second instance or allegation where the same affiliate broker, the same respondent, was not caught on camera, but rather the owners who were selling said they had some narcotics missing from their medicine cabinet. The respondent says, yes, I went through and got Excedrin and was caught on camera. He admits that, and that's when he went to this local Realtors Association. They imposed $1,000. Well, they probably do much as this commission does, a civil penalty or a fine, however they characterize it. In addition, he did this C2X, and I think he also got himself some counseling as well. But he's adamant that he did not take, and this is just information that the respondent gives me. That's the only way that you all would be getting it otherwise. So he explained to me that yes, that was me taking the Excedrin. I was on camera, but I didn't take the narcotics from the second house.
First case.
So the commission voted to do a 6-month suspension. At some point, prior disciplinary counsel brought it back for a 3-month suspension and a $500 civil penalty, and then the commission voted to just sustain their previous decision to impose the 6 months. So now we're back.
So at the moment, the decision that's in effect is 6 months suspension.
Correct.
So there's not necessarily a need for Ms. Frank's motion.
Right.
Because that's what's in play at the moment.
Correct.
And just to be clear, the narcotics that had gone missing are prescription narcotics.
Yes, they were for, I believe, like a dental procedure.
Just to be clear.
Oh, Marcia, you can.
Well,
I'll suggest you could withdraw your complaint, and we'll just take no action on this, and the previous action stands at that point.
Then that would be fine with me, because the new recommendation was just to discuss anyhow. So,
right.
Okay, then we'll just, unless somebody wants to vote on it, we can just let but the previous was the 3-month suspension at $500, where the first one was 6 months suspension.
But that did not pass.
Question.
No, it did pass. That was the decision.
The 3-month?
Mm-hmm. It was.
Look.
It did pass.
No, it looks to me like it says.
It was 6 months, and then they came to us with some more
I think
information.
it says that they kept the original decision.
Yeah, if you look at the decision.
Down here.
Mm-hmm. Right underneath there, right where your finger is.
So, and that decision then is a 3-month suspension?
No.
No, that was the rec.
6
yeah.
months, okay,
Yeah, so
okay, then I'm good.
Question.
Yes.
When does the 6 months run from? The
When they
point
sign it.
in time when they accept it? I mean, this is so long ago.
They didn't accept anything.
They haven't accepted it.
The 6
time would
months
run
would-
long ago.
The 6 months would run if the respondent signed the consent order today. It would start tomorrow.
There's going to be a formal hearing.
But how many times can they bring it back before us?
Well, this is essentially the last time that
Yeah, this is
I
the
would
third
bring this
time.
back to you. Given the new information and this is the first time that anyone was hearing that, well, I thought all this was over. I mean, that's essentially what the respondent is saying, that he misunderstood. Well, whether it's real or not, he claims to have misunderstood that the association's actions cleared up this matter, and of course it did.
And where is his principal broker in all of this?
Whistling past the graveyard.
That's another deal.
Broker released them. I think.
They broker released them.
Oh, okay, then they did the
So
right thing.
his license, according to this, expired on January 13th. So how does that work?
That was my question. That was my concern as well.
This might not be updated. I could go on and see if what the license information.
It may have been put on there when it was originally opened.
Correct. It most likely is up to date.
Don't know if they're expired or not.
All right,
Yeah,
the
I
chair-
can take a look
the chair
and see
is-
if they've renewed.
Let's looking it up.
Well, the chair, in the meantime, is going to rule that there is no motion in play on this
Okay.
case number 44, and we're going to move on to number 45.
Okay.
Ms. Smith.
It was up for discussion. I pulled it.
This is a reconsideration. And council's recommendation is not to pay any attention to the reconsideration and stick with your original decision.
And I bring this one back because, well, it was a one that we had seen last month, actually. So the complainants don't believe they've been harmed. So they're saying, we didn't even open this against our broker to begin with. We opened it against the listing agent who we feel is at fault. But I think the commission at the last meeting pretty well discussed that they feel that the buyer's broker could have exercised more reasonable skill.
This is the one where the sign was on the wrong property.
Right.
Okay.
And council's recommendation is to sustain the commission's decision to impose the $1,000 civil penalty.
Right.
Chair is happy to make a decision that no motion was forthcoming on this case, and so original decision stands. Unless somebody wants to make a motion, we're going to move on to the next case.
I move to sustain council's recommendation because the excuse that it was no use to look at the attached documents and that the photo in the description was conclusive, which is what the buyer's agent's remark was, is not diligent and reasonable skill and care.
All right, so we can all go that way as well. So the motion on the floor is to sustain the previous decision. Ms. Frank seconds that motion. So if this motion passes, there'll be a $1,000 civil penalty offered to this licensee. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. Number 46. Joan?
I'm going.
Oh, and Anna, thank you. First of all, thanks, Dennis. Anna's got these next few cases.
Let me see. I have in my notes to make a motion to agree with the recommendation of a $1,000 civil penalty. I'm trying to refresh myself. I'm going to make that motion, and we'll get a second to discuss if there's anything to be done.
Motion to accept council's recommendation. Is that your motion?
Yes, sir.
Okay, motion by Ms. Smith. Ms. Frank seconds that motion, and the motion is to accept council's recommendation. Now discussion. Joan?
In my notes, I have to make a motion to agree, so I must have agreed to it when I read it, but I'm skim reading it right now. So I'm going to stand by that.
You ready for us to vote?
Yes, sir.
All right. You've heard the motion. It's to accept council's recommendation. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. And that motion passes unanimously. Number 50. Anna, I just had a quick question about this.
Yes.
It refers to a third party as holding money.
Uh-huh.
Is that like a title company or?
It is.
Okay, so it's not like.
No.
They're affiliated with the transaction in some form or fashion.
Yes, it's a title company.
The chair would entertain a motion to accept
Move to
council's
dismiss.
Second.
by Ms. Frank, second by Ms. Smith, that this complaint be dismissed per council's recommendation. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no, and that motion passes unanimously. 52.
That was me, and the recommendation was to dismiss and administratively open a complaint against respondent's principal broker.
I think all three of you pulled it.
Oh, okay. Then I'll let somebody else.
What did you say? What did you say, Ann?
I said I think
have
you
it too.
and Vice Chair Franks all
We all
three of
three
you
pulled it.
pulled the case.
So this is a case that just kind of gets under my skin
Oh,
where
it's
there's
the
a team.
Team, yeah.
And a member of a team violated advertising. Is that correct?
You want me to read it?
And apparently,
Great. I don't
somebody in
want
the firm thought the team leader was responsible for the advertising violation. Well, in fact, it looks like the principal broker was the team leader, according to this. Is that
Right.
And
I'm not sure.
The principal broker takes responsibility.
Yeah, my only point is that you can call yourself a team leader all you want to, but the liability rests with the principal broker.
Right.
And with that said, I'm ready for a motion to approve council's recommendation.
Second.
Motion.
To dismiss it?
I'll make the motion, sure.
Thank you, Jeff.
I'll say.
Smith seconds that motion, and the motion is to...
And are you going to, okay, so we're going to open a complaint against respondent's principal broker.
Yeah, we're going to dismiss the complaint, and council's recommendation is to open up a complaint against the principal broker.
I would like to know, because this is against an unlicensed person, so was there somebody in the team that did this?
No.
That wasn't licensed?
The complaint was open against the team name. So our centralized complaints division didn't open it against like the firm or the principal broker, but it was connected back to the principal broker, so it is actually opened under the team name.
Did you, Anna, have any thoughts about a civil penalty against the affiliate broker as well? But I know we couldn't with this complaint.
Well, I didn't know the information about the affiliate broker until the principal broker wrote it, because it's a postcard with all of the members of the team on the back of it. So I didn't know exactly who was responsible for the mailing.
Now that the principal broker...
Despite that, I still think it's the principal broker's responsibility to know that.
So the motion is to accept council's recommendation, dismiss this complaint, and open a complaint against the principal broker of this company for failure to supervise. Discussion? Let's vote. Those in favor of that motion vote aye.
Aye.
Those
Aye.
opposed, no, and that motion passes unanimously. And number 55, John.
That's me again, and the same, was on a roll. This one bothers me. Complainant claims respondent provided the lockbox code to view the home and states they visited the property 3 or 4 times without anyone but their spouse. So here we go again. We have someone who is a licensed affiliate broker giving out lockbox codes.
The issue in that is that the respondent doesn't say that they do. And both parties, I really don't find either of them to be credible, so I don't know if that's true.
But then in here it says, after a few days, complainant returned the key and respondent later changed the code box to a super key box.
Yeah, that's what the respondent said. I don't know what happened here, like by either of the individuals. I know that it was, I could tell things didn't go well between the complainant and the respondent, but the reason I didn't take any steps to look further beyond the documents was because the transaction fell apart, and none of the other parties had complained specifically about the lockbox situation. And after reviewing these kind of complaints, you can tell when they're complaints that are done out of retaliation and when individuals are just saying things back and forth. And there wasn't a lot of substance in the complaint, so I'm not sure that is exactly what happened in this matter.
So, with that said, the attorney appears to have some problem believing anybody in this case.
Yes.
Just trying to see if I can summarize it. That's why she suggests we dismiss the case. What do you think, Ms. Smith?
I personally don't like giving out codes. You know, I've already expressed that.
You're on record more than once.
Thank you, dear.
Well, and here's something else to consider. The listing agent listed the property as being available to be sold via cash or conventional loan, mobile home on a piece of land. At some point in time, the complainant's lender, I'm understanding this, indicated, hey, there needs to be stairs and this and that. The complainant did those stairs. House didn't end up selling. Seller did not come off on the price, which that's not the respondent's fault. Was the consumer affected in this? Yeah. Time, money, whatever. So I don't know if a civil penalty is in order to the respondent, but letter of warning may be for reasonable skill and care, because if you're on a list of property, they've been licensed since '01. I don't know. There's a lot of things sometimes you don't know in this industry till you know. But maybe that should have had stairs there going to that door.
I don't know why before they closed that they would put the stairs on there, though, you know?
Well,
Except that they had to.
yeah, that's a good point. They accepted that. They accepted that risk. I have had clients on on homes back in the day, back in a different era and market. What was it? I guess it was a short sale home with the lender that they threw some paint on a wall, so they risked that.
Yeah.
So sure, that's the complainant's risk.
My understanding was that when they went to their lender, it was the lender that was asking for the stairs, and it may have been something about a deck or something of the sort to add to the property for it to qualify for a loan. And then once those were added, it was sufficient, but there were title issues, and there were tax arrearages attached to it, and the seller did not want to pay those.
I think my motion is to issue a letter of instruction to the respondent to maintain reasonable skill and care, meaning understand what you're listing, understand what you're selling and putting out there to the market, to the consumer. Again, the complainant is responsible for what they can do, and that would be my motion.
Is there a second? I've got a second by Ms. Franks. Further discussion? All right, you've heard it. Steve?
This will be their second letter of warning 13 years ago.
So does that affect anything you want to say, or?
Good point.
What's
In
the difference in warning
2009.
and instruction?
Yeah, this is less of a. What your proposal was? What a letter of
instruction.
And that's less than warning.
a letter of warning.
Yeah.
He or she has already received 13 years
Yeah,
ago.
the respondent can't control what the seller agrees to or not. Did the complainant have a agent? I don't remember.
It just says they're out of,
No, they
they're
did not.
Tennessee resident.
They did not.
Probably
If they
trying to save
did, I
money.
didn't have that information.
I'm content with the letter of instruction.
Right.
All right, so the motion on the floor, properly made and seconded, if passed, would ask council to send a letter of instruction to the respondent talking about the importance of reasonable scale, reasonable care in the transaction. Reasonable scare, Anna.
Give them a reasonable scare.
Give them a reasonable scare, would you?
When they see the envelope come through.
All right. Let's vote on that motion. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. And that motion passes. For everyone's information, that was the last case we're going to hear today. I'd like to once again brag on council for having to work through these dozens and dozens of cases and try to put them together in a fashion that we can understand. And lawyers sometimes think differently than real estate agents. And they do a great job of doing it. Anna has many jobs in the Department of Commerce and Insurance. You're not just real estate commission. And Dennis, for those of you who don't know, also is in the military. He's a judicial...
A JAG.
A judicial advocate officer. And he occasionally, we won't have him because he'll be in some desert somewhere over in Saudi Arabia. Where was your last deployment, Dennis? Kuwait. So he's serving the state and the country and doing a great job at both. And we appreciate both of you. All right, a couple other things. Commission. This is for commission. There's at least one person in this room who got here after I asked that the sign-up sheet be picked up. And so that person, and there may be more than one, but at least one person asked me for some sort of consideration so that he could get credit for attending this meeting. What are your thoughts at this point?
How late were they?
Well, let's say it was 35 minutes.
I'm good.
Are we saying, or was it 35 minutes?
Okay, 35 minutes and 30 seconds.
I make a motion, we accept them.
So,
I'll second it.
so if that person, here's what I'd like to do to show his good faith. He should be the last person to sign out, which will keep him in here.
We'll all know who that person is now.
Well, that's okay. Everybody else will be gone by the time he signs
Oh,
out.
okay, that's right, that's right.
So, thank you for that. Let's see what else I had. Once again, I want to thank the Memphis Area Association of Realtors for their hospitality, and, as importantly, the Germantown government for letting us use this facility at no charge.
Nice.
Very, very nice facility. You guys have been a great audience, and we appreciate that. Finally, and I don't know how long this policy is going to stay in place. It used to be more appropriate than it is now. For those of you here to get credit, you're going to get 8 hours of credit for attending about, 3.5 hour meeting. It's one of the. Now, if you would like, I can ask Commission, should we vote on that and change that policy now, or save that for another time? So,
John, so you're
on your way out, please, no stampedes, get a single line. You could have been here for all day today and all day tomorrow, which Isaac knows is how it used to be, and that's why the 8 hours came from. It was 2 long days. It's a deal. Caitlin, what do you have for us?
I think there's one more item.
I got that. I see it. So this commission occasionally, and not very often, awards an award called the Bill Toon Award, and it's to recognize people who have been important in the education of real estate agents and consumers across the state. And there are 2 members of your association who we've not been able to find a time to present the awards to. So this morning, I would like to at least acknowledge the fact that Fontaine Taylor and a gentleman by the name of Rick Douglas, who served, both of those people were great assets to this real estate commission, have been awarded that award. And we will find the right time to get them their plaque, but if you see either one of them, tell them we were thinking about them and we appreciate their effort, especially Fontaine. She's a legend. She's a mean old woman, though, isn't she?
No, she's not.
No, just
She's
checking.
not.
Just checking. She's a great lady. So for that. All right, now, Caitlin, anything else? All right, Commissioners, let's go around the horn here. Joe, you have anything?
So you're not going to make them stay and watch the video?
Make them do what?
Stay and watch the video for the next 5 hours?
No, we're not watching videos.
What video?
We're not watching videos. We're going to go to work and make some money, right? Jeff, the West Tennessee Commissioners have been our official hosts. Thank you, Steve, and thank you, Jeff, for what you did to put this together and get this thing going. This is the Strawberry Queen Festival princess right here, and she also had a part to play from Humboldt. So thank you all. We appreciate coming to West Tennessee. By the way, state law requires that we do this. That law was passed maybe around Ned Ray McWhorter's time as governor, and there were some people who thought it would be a good idea to take this meeting to East and West Tennessee at least once a year, and I hope you all appreciate the fact that it should, I hope, was beneficial to you to learn some of what we have to handle. So thank you for your attendance. And please be safe, and please be professional, and have a great rest of the day. Thanks. We're adjourned.
Did we need to do anything on that?